muted. I'm unmuted. Can you hear me?
Yes, ma'am.
Good morning.
Okay. Yeah. Good morning. You can.
Good morning.
Major, does it make it easier having a uniform when you're having to choose what to wear for the hearing?
It does, yes, but it's not the most comfortable. I definitely prefer my, my camos that I normally wear every day.
Do are there different uniforms for different occasions?
Yes, we have 4, but one is, so the service dress is this. We have something called a mess dress, which is for like formal, like the Air Force Ball and things like that. I think I've only worn mine twice. Then our OCPs are like the camo type uniform that we wear every day. And then our fitness uniform.
Oh, okay. No, I guess I'm a victim of television or movies, and I see nice white outfits. Is that a different branch of the service or?
Yes, the Navy, I believe, has the white outfits.
The white? No khaki? No khaki outfits?
The Coast Guard, I believe, has, I think they wear khakis. I went to a course once with some Coast Guard folks, and I think they had something like that, a uniform like that.
Okay.
Not their normal, like, again, camo type uniform. But
I went to law school with some former Air Force personnel and or spouses of Air Force personnel, and I would kid them about going their service or going into the service, and they said, well, that they chose a certain branch of the service because they had the best uniforms.
Oh, well, I've not heard that, but I have heard the best locations and installations. And I will say, I think the Air Force has some pretty good locations and installation quality.
Okay, good to know.
But the Navy's always by water, so that's also a plus. But then you may have to end up on a ship. So.
No, I like the water. That I think that would have been fine. Perhaps in another life. I can recall when there were interviews at my law school, and I think the only one that actually had space were the Marines. And the gentleman was very quick to tell me about crawling through the swamps. That JAG officers were not exempt from the regular PT, and I think he thought that would discourage me, not knowing that as a child I loved to play in the mud. So
yes, the Marines are a little different that way. With their JAG officers we're all officers first, but they're definitely a little bit different in that respect.
A little different, even after all these decades. Same sounds like. Are we going to have any procedural matters that we need to deal with this morning before? Yes, ma'am.
Sorry, I didn't mean to interrupt you.
No.
Jocelyn Barrett Capon on behalf of Walmart. I just wanted to be able to advise my client whether he's going to need to get onto the Zoom this morning. You had reserved your decision until this morning. I just wanted to give you a heads up.
My understanding is that there are questions from one of the commissioners for Mr. Chris. So the answer to that would be yes.
Okay, I'll let him know. Thank you.
All right. And I thought I saw him pop up there for a second.
Yeah, he has the link. So he's
okay.
ready whenever.
Okay, very well. Anything else procedural that we need to talk about this morning? Again, we're streaming already, but I do have a question that Mr. Lee, are you nearby?
I am. You mean I am in Santa Fe, if that's what you mean.
No, I just wondered if you were nearby your audio and video.
I am.
You are, sir.
Perhaps you can't see my tiny head.
I kind of wish I had that camera view that I was way away. But
I'm laid back, Judge.
if I'm way away, then I can't touch my papers. And so,
I know you've grown quite fond of your papers, so I wouldn't want to deprive you of that.
Exactly. Yes. I try to be as ecological and environmental as I can, but I do love my papers, but I do recycle them.
Judge, just for your information, for the briefing schedule, I think the transcripts will be done likely by close of business Thursday, but if you give me to close of business Friday, I think I'll have it buttoned up. Okay,
very well. I appreciate that, sir. I just wanted, is there a way, Mr. Lee, that you can check in the computer as to my question about bench request number 2, which I believe is the only bench request, commission bench request.
Was that on the first day?
Or not bench request, commission exhibit. It was the first or second day.
You want to know what it is?
I want to know if that's the only commission exhibit that I've admitted.
That is the only one you've admitted.
And it's number 2. And what was it?
It was a bench request response, and I'm looking for it.
Okay. I know what I think it is. Well, Mr. Lee is looking. Anybody else got anything procedural that we need to discuss before we go on the record? We've got about 1 minute.
This is Kara Lynch with
Ms. Lynch?
CCAE. Our witness Noah Long will likely go today. Is my understanding.
Yes, ma'am.
He is experiencing some internet issues. It's up for now, but I'd request permission to keep you informed should anything happen.
Either that, Ms. Lynch, or perhaps he's in Santa Fe, correct?
Right now, he is not in Santa Fe. I'm not exactly sure where he is.
Okay. I was going to suggest he come to your office, but if he's not in Santa Fe, then that won't work, will it?
He's working on a stable connection. I just want to keep you informed as needed.
And if he can't get a stable video connection, I mean, we'll see. But if all we can get is audio, I'll settle for that as long as it's stable.
Judge, Commission
I'll inform him. Thank you.
Commission Exhibit 2 was Ms. Crane's response to the bench request provided by NMAG.
Okay,
I'm ready when you are,
thank you,
Judge.
sir. Very
Madam
well.
Oh.
Ms. Hardy.
Sorry. I just wanted to ask you, and it relates to the bench request, whether they will be admitted into evidence. I think SPS would actually prefer that they be admitted because I think they illustrate topics of discussion in the hearing.
Yeah,
And I know
yes,
there have
ma'am.
been several.
Yes, ma'am. And I believe that SPS actually filed the bench requests yesterday. The answer to I don't see it.
We did file one, and I'm just.
It's the answer. I asked Mr. Berger to change Exhibit A so that it would show.
That's bench request 9, Judge.
Yes, sir. I wanted Exhibit A, page 1, to reflect the total base rate percentage increase along with the fuel. Is that right, Ms. Hardy?
I believe that's correct.
Okay. Very well. And so the answer is yes. And I just have to make sure all my numbers are correct. On those, and I'm going to offer those after we finish with the witnesses to see if anybody has any objection. And also if anybody's going to want the opportunity to respond pursuant to the commission rule, I believe 35.
Thank you.
Okay, very well. If we don't have any other procedural matters, good morning. My name is Elizabeth Hurst. We are continuing our case number 22-00286 in the matter of SPS's request to revise its rates and other requests that concern abandonment and or extension of generation assets. And we are resuming our hearing day 6 in this matter. And we are resuming our evidentiary portion after having a brief discussion off the record on some procedural matters, primarily having to do with responses to commission bench requests made prior to and during the hearing, which will in fact be admitted at a later time. Along with me today is Chairman O'Connell and Commissioner Ellison, who may have questions for some of the witnesses. Good morning to everybody. And based upon the presentation of the witness order. Now is the appropriate time for Walmart to present its witness. And did I lose Mr. Chris?
He was in the waiting room.
And I let him in and
pardon me for, let me send him a message.
okay. After Mr. Chris's examination has concluded, then we will return to presentation of staff witness, and I believe that the next witness is Ms. Dashino. There he is again. Let's try again. Nice picture of water for Mr. Chris. I don't know if that's real. Maybe that's why we're having trouble with the connection. He's out on the water. Lost him again, Miss Barrett-Capon.
My apologies, Your Honor. Let me see if I can.
Now he's trying to join again.
He hadn't advised that there would be problems with his connection, so I'm not quite sure.
Hello there, Mr. Chris.
Hi, good morning. Sorry, my computer was having connection issues.
I thought maybe that nice picture of water that I got, you were out on the water. I was a bit envious there.
I wish. The weather is beautiful, and I would rather be out there than in the office today.
Been here, absolutely. Well, we appreciate you appearing here today.
Happy to
Mr.
do
Lee,
it.
would you please swear the witness, sir?
Yes, Your Honor. Mr. Chris, would you please raise your hand? You solemnly swear the testimony you're about to give in the matter up and should be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you, sir.
Good morning.
Go ahead, Miss Barrett-Capon.
Good morning, Mr. Chris. Would
Good
you
morning.
get your full name for the record?
My full name is Steve W. Chris. Last name is spelled C-H-R-I-S-S.
Thank you. And who are you employed by and in what capacity?
I am employed by Walmart Inc. as Director Energy Services.
And who are you appearing on behalf of in this proceeding?
Walmart.
Thank you. Do you have in front of you the document marked Walmart Exhibit 1?
I do.
Can you identify that document, please?
I believe that is my testimony.
And are there attachments to that document?
There are, and I don't have those immediately in front of me. I apologize. Let me grab those.
I believe there are 4 attachments to the testimony. Was the testimony and those accompanying attachments prepared by you or under your direct supervision?
Yes.
And to the best of your knowledge, is the testimony and the exhibits accurate and true?
Yes.
If I asked you the same questions in your direct testimony today, would you give the same answers?
Yes.
Walmart moves for the admission of Walmart Exhibit 1 to the record.
And just to make sure, you prepared your attachments to your testimony, or they were prepared under your direction and control, sir?
Yes.
Any objection to what's been identified? Oh, and Ms. Barrett-Capon, the version of Walmart Exhibit 1 that you're asking to introduce is in fact the version that was placed in the Dropbox?
Yes, ma'am.
Any objection to what's been identified as Walmart Exhibit 1? Mr. Chris, direct testimony as verified by him here today. Hearing no objection, Walmart Exhibit 1 is admitted. Is that correct? Or you only have what, you only have Walmart Exhibit 1, is that correct?
That is correct.
Very well.
That being done, Walmart tenders Mr. Chris for questions.
Thank you. And Mr. Chris, just so we get this clear on the record, what type of service does Walmart take from SPS?
So my understanding is we take service under the secondary general rate. I have that in my testimony. Let me just double check. Yeah, we're secondary general service. We have 6 stores under the company in New Mexico.
Okay. And it's also my understanding that you did not file stipulation testimony in this case, correct?
That's correct.
But Walmart signed and supports the stipulation in this case, correct?
That's correct.
Okay. It's my understanding that Commissioner Ellison has some questions for you, Mr. Chris. Commissioner?
I do. Good morning, Mr. Chris.
Good morning.
I hope I'm not the only reason you're not on that beautiful Arkansas lake this morning.
You are not. So don't feel
Okay, that makes me feel better. Because I just have a couple of quick questions about your testimony. Did you recommend an ROE?
Second. So we didn't recommend a specific ROE, but provided some information for the commission to benchmark the approved ROE in this docket against.
I'm sorry, the approved ROE and?
Against which the commission could benchmark the approved ROE.
So I guess turning to the equity ratio question, that is not something that you addressed. Am I correct?
That's correct.
Mr. Chris, I notice you have an impressive amount of experience in testifying on rate cases. Is there any reason you chose not to comment on the capital structure?
We typically don't address capital structure. What we normally do in that part of the docket, or a rate case docket more generally, is address the ROE portion and talk about where national trends are. Capital structure tends to be a little more unique to the utilities themselves, and so to that extent, there's a certain amount of it's less of a fact-based argument than looking at the ROE and what the national trends are doing and where the industry is.
I see. Could we look at your exhibit 3? I have that on page 59 of the PDF file that you sent.
Sure. Which page are you looking at? Towards the bottom, or?
So this is the last page of that exhibit SWC3. It's on the PDF, it's page 59.
I'm there.
Okay. So if we look at 2022 and the approved equity ratios for the average of these companies, it's somewhere between 50.5 and 51%. And this is as far as this is S&P data. Correct. And they are reporting on equity ratios that were approved by state commissions, correct?
That's correct.
And so it looks like the average of these approved equity ratios in 2022 and 2021 was quite a bit lower than the 54.7% that SPS requested. Does that strike you as as interesting that there's a 4 percentage point roughly difference between what they're asking for and what the average was?
Yeah, I mean, it certainly it definitely strikes me as interesting. Because so ultimately the equity portion of their weighted average cost of capital will be higher because that number's higher.
Right. And do you have any thoughts on whether it would put SPS in financial difficulties to have an approved equity ratio sort of more in line with the averages?
So we haven't taken a position on that. And so without providing supporting analysis, I would hesitate to take a position on that.
Okay, that's fine. What are your feelings about the settlement in general? Are you disappointed in any aspect of the settlement?
Well, I mean, ultimately, settlements they're an arm's length agreement between the parties to resolve all the issues in the case. So there's always going to be some push and pull. I think the settlement is fine. I mean, if we didn't think it was okay, we wouldn't have signed it. So yeah, in the totality of the settlement, I think it's okay. We're good.
Okay. Great. Well, thank you, Mr. Chris. I think those are all the questions I have right now.
Thank you, Commissioner. I was trying to pull up that chart, but I couldn't figure out how to rotate it, and it was inverted. So I didn't bring that up. Sorry.
That's fine.
In looking at the Exhibit A, which has now been modified to be bench request 9. Under the original Exhibit A to the stipulation, do you see that, Mr. Chris?
I do.
Exhibit A. So basically, and it's entitled Exhibit A, page 1 of 6, revenue distribution. And you said you take under secondary general service?
That's correct.
So in essence, 3.76% of the allocation goes to secondary general service.
Well, essentially the increase for the class is 3.76%. In terms of the allocation of the revenue, I'm not sure.
Well, just looking at this, the increase
Mhm.
is among the lowest of the rate classes, isn't it?
That's correct. And I think that's reflective. I need to pull up. I've got the relative rates of return. So looking at, so this is on, let's see, it's table 1 of my testimony, which I believe is on page 20. Look at the relative rates of return to understand where each class is relative to the company's cost of service. Secondary general service has it's 1.82, or so 1.82 times the average or the jurisdictional return for the company, which is the highest amongst all classes. So in terms of its position as a subsidizing class, it's certainly the most significant of classes that are subsidizing other classes. And so the revenue allocation generally reflects that. So you look to assign below average increases to classes that are subsidizing, and so below average increases to classes that are subsidizing, and above average increases to classes that are subsidized.
And so that leads me to my question of, did you redo that number based on the stipulation?
No, that the number, the relative rate of return that I mentioned is from my testimony. I didn't recalculate that. That was the coming in number.
Exactly. But I want to know I want to know what your opinion is on the actual number that was achieved. And based on the
where that number
based on the exhibit that I just had up.
Mhm.
The secondary general service was being allocated a 3.76% increase. And if you look at that compared to the other increases, it's among the lowest, isn't it?
That's correct.
And is that the primary justification for your employer to sign the settlement?
Well, I mean, there are several things that we get into cases to deal with, but one of them is to address subsidies that exist in rates. And so the company came in and showed that those subsidies did exist. The settlement, by providing a below average increase for the class, addresses that somewhat. I haven't recalculated it, so I don't know the extent to which the subsidy is addressed. But
the subsidy is
addressed, sorry. But yeah, I mean, that's certainly something that that we take a look at, because ultimately, our position is that rates need to be set at cost. So if we were on the other side of that, we wouldn't oppose moving our rates towards cost of service, just because it's important that rates reflect the cost that the utilities incur to serve each class.
And do you believe that that the way that the rate design has shaken out now with the $33 million and the percentage that's allocated towards secondary general service accomplishes a reduction in the amount of subsidy that secondary general service provides?
So I haven't calculated the specific number, but based on my experience, it will address that subsidy to some extent.
Okay. Were there any other parts of the stipulation that that you feel were more important or impactful to Walmart's decision to sign the stipulation, if you know?
I mean, again, in you know, it represents push and pull. And so as a total package, we were okay with it. And ready to sign.
Very well, sir. Thank you. If there, Ms. Barrett-Capon, any redirect?
No, ma'am, I have no redirect for Mr. Chris.
Okay. Anyone have any questions based on Commissioner Ellison's questions or my questions? Hearing none. Mr. Chris, thank you. Appreciate your time. Your excuse, sir.
Thank you.
Anything further, Ms. Barrett-Capon, from on behalf of Walmart?
Nothing further.
Very well. I believe then we are going to continue with questions for staff witness and Mr. Bagatko. I see there's Ms. Dashino in the waiting room. Good morning, Ms. Dashino. How are you? Just need to.
Good morning.
There you go. You're unmuted. Mr. Lee, would you please swear the witness?
Yes, Your Honor. Ms. Daxton, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter of opinion to be the truth, whole truth, and nothing but the truth?
I do.
Thank you, ma'am.
Thank you, Mr. Lee. Mr. Bagatko,
Madam Hearing Examiner, thank you. May I proceed?
please.
Good morning, Ms. Dashino. How are you?
I'm great. Good morning to you.
We have a couple items to move into the evidentiary record, so if you bear with me, I'm going to proceed to do that. Is that all right with you?
That's fine.
All right, well, let's go to the first item. It's been provisionally marked as Staff Exhibit 3, and it consists of your prepared direct testimony in this case that was filed on April 21st, 2023. You have a copy of that in front of you?
Yes, I do.
And that is the copy that was uploaded and presumably downloaded by you from Dropbox, correct?
That's correct.
Well, thank you for that. Would you take a moment and just flip through Staff Exhibit 3 to make sure that it is a complete and accurate rendition of what you had filed in this case on April 21st?
It is.
And what we see there, that was all prepared by you or under your direct supervision, correct?
Correct.
And that would include Appendix A and then your two exhibits, Exhibit GSD1 and GSD2 attached thereto, correct?
Correct.
I also understand, Ms. Dashino, that you do not have any corrections to make to your prepared direct testimony. Is that still the case?
That is still the case.
And now finally, Ms. Dashino, if you were asked the same questions as we see posed in your direct testimony today at this public hearing, would you have any cause to change your answers or would they remain the same?
They would remain the same.
With that, Madam Hearing Examiner, I would move for the admission of Ms. Dashino's prepared direct testimony into the evidentiary record marked as Staff Exhibit 3.
And Staff Exhibit 3, Mr. Bagatko, was in fact the version that was placed in the Dropbox.
That is correct, Madam Hearing Examiner.
Thank you. Any objection to what's been identified as Staff Exhibit 3, Ms. Dashino's direct testimony as verified by her here today, and which copy was placed into the Dropbox? Hearing no objection, Staff Exhibit 3 is admitted. Mr. Bagatko.
Thank you. All right, moving along, Ms. Dashino. Now we're going to talk about your prepared testimony in support of the contested comprehensive stipulation, which has been provisionally marked as Staff Exhibit 4. Do you have a copy of that in front of you?
Yes, I do.
And the same as before, this was the copy that, per your understanding, was uploaded to Dropbox?
That is correct.
Would you take a moment, please, Ms. Dashino, and just flip through Staff Exhibit 4 to make sure that it's a complete and accurate rendition of what you caused to be filed in this case on May 26, 2023?
It is.
And this was prepared by you or under your direct supervision, correct?
Yes,
This time around, we don't have any exhibits. It's just your testimony with with an affirmation and a COS, correct?
correct.
And a COX.
COS, I'm sorry, Mr. Lee, Certificate of Service.
Thank you.
You're welcome. Ms. Dashno, regarding Staff Exhibit 4, it's also my understanding that you do not have any corrections to make to this item. Is that still the case?
That is still the case.
And finally, Ms. Dashno, if you were asked the same questions today at this public hearing as we see posed in that testimony in support of this stipulation, would you have any cause to change your answers?
No,
Thank you for that. And with that, Madam Hearing Examiner, I would move for admission into the evidentiary record, Ms. Dashno's prepared testimony in support of the contested comprehensive stipulation, which has been marked as Staff Exhibit 4.
Thank you. Any objection to what's been identified as Staff Exhibit 4, Ms. Dashno's testimony in support of the contested stipulation placed in the Dropbox, verified by her here today? Hearing no objection, Staff Exhibit 4 is admitted.
Thank you. And it's my understanding, Madam Hearing Examiner, that nobody's reserved any cross-examination time for Ms. Dashno, but that you and the commissioners may have some questions for her. So I would tender her for that examination, please.
Thank you, Mr. Bagatka. How are you doing this morning, Ms. Dashno?
I'm doing great. Thank you.
Excellent. My understanding of your direct testimony is that the purpose of your testimony was to provide review and analysis of the revenue requirement. Is that correct?
That's correct.
And I guess suffice it to say that staff was not in complete agreement with what SPS proposed, was it?
That's correct. We did make some adjustments.
As a matter of fact, you actually made a number of adjustments such that your ultimate recommendation of the appropriate revenue requirement was approximately less than half, wasn't it?
Around, yes.
In fact, it was 36,930,982.
That is correct.
Can you characterize was it a whole lot of little adjustments, or did you have some really big adjustments that that jumped out at staff that you thought were appropriate?
I feel that they were little adjustments, and I believe if you give me a second, I might have detailed. I think the biggest adjustment came from our ROE, but I want to make sure I have that.
Can you say that $36,000 number again, the whole number?
I believe that the number is 36,930,982.
Thank you, Judge.
Thank you. Well, I know on page 6 of your direct testimony, you are, well, you begin talking about certain adjustments on page 5 to various accounts, miscellaneous account, etc. And like I say, I just wondered if for purposes of the record, you can characterize where the majority of that $36 million plus adjustment came in.
Yes, so the ROE was the largest impact to the revenue requirement, 24 million reduction. And
Okay.
then the Schedule 11 revenue adjustments came in at 12 million. And so those were the large impacts to the revenue requirement. Everything else was really small, $1 million, 1.6. And, you know, I think the rate case expenses as testified by Naomi Velasquez.
I'm sorry, testifying by?
Naomi Velasquez.
Those were the Rule 530 donation adjustments?
And the rate case expenses.
And you said 26 million on the ROE reduction?
24, well, actually, I don't want to state a specific number because I didn't update this with the refiled testimonies. I had done this prior, and then when we readjusted, I didn't plug in the new numbers. So roughly 24 million, let's just say that.
Okay. Why didn't you update it?
I don't know.
Okay. And then, so 24 million on the ROE, and then the Schedule 11 were the other big ticket item?
Yes. That one came in roughly around 12.5 million.
So that's approximately 36.5 million of the adjustment.
Pretty much so.
And can you define the, according to your testimony at page 5, the account 51 Schedule 11 network transmission? Is that all that's in Schedule 11?
Let me go to. Okay. Schedule 11. Yes.
I'm sorry, Mr.
Yes,
Ash.
that is correct. Sorry, I just had to read through it.
And can you recall why there was such a big adjustment in that particular account and or schedule?
On page 6, there was an analysis done about the revenue and how it's increased from 39 million to 239 million, and that's page 6, line 17.
Yes.
In 2022, and increased substantially every year. So if you look at exhibit GSD2, that's where the calculation was done to come up with that increase in revenue.
Okay. And you didn't believe that was an accurate portrayal of what that expense was going to be?
Well, it was a revenue, right? So if we increase their revenues, then they're going to have a lower need, a lower deficiency. So it necessarily wasn't an expense. It's just we didn't believe they accurately reflected their revenues. So in increasing their revenues, it reduced their revenue deficiency.
And Was that adjustment accepted in the rebuttal case?
It was not. I believe SPS rebutted that adjustment.
So then do you believe that staff's assertion was incorrect? Or do you maintain, even though SPS attempted to rebut it, I mean, did staff still maintain that position after the rebuttal testimony?
I mean, it was included in our revenue requirement, so our position as when we filed it stands. And based on the stipulation, staff could gather that it was included because the stipulation offers a lower revenue requirement than what we recommended. And it was not addressed in the stipulation.
Right, but do you think you made a mistake is my question.
I can't recall the exact testimony who rebutted this, so I could not answer that for you. I'd have to go back to review it.
Further on in your direct testimony, Ms. Daschino, you addressed the regulatory asset requests from SPS. Is that correct?
That's correct.
And staff recommends denial of SPS requests for regulatory assets.
That is correct.
And you cite to various prior commission cases as support for this position, don't you?
That is correct.
However, I mean, SPS and some of the other utilities do have regulatory assets currently, don't they?
Currently, they do, yes.
And what makes these requests different from the requests that were previously approved?
Well, this case 2183, and I'd have to go into the record to see when the actual final order was issued. And using this, I suppose, methodology or this opinion looking forward was my intention, not looking backwards.
So then you believe that the commission has a precedent now that that utilities shouldn't get regulatory assets treatment?
I don't believe that in 2183 the issues have been completely resolved. Those are ongoing now in the PNM rate case. So I believe when that gets decided, there would be precedents set.
Has staff filed testimony in that case?
Yes, it was filed on Friday.
And were there any regulatory asset requests in that case?
Yes, they were. Yes, there was.
And did the staff take a position similar to the position that you took in your direct testimony here, that regulatory assets should not requests for regulatory assets should not be granted by the commission?
No, if we look at the testimony that I filed here, they should be doesn't oppose the creation of regulatory assets. They should be the exception, not the norm. And I believe the regulatory assets that were allowed in staff's testimony had to do with leasehold leases. And honestly, I had not found a case of the commission with those leasehold expirations and what to do with the cost. And I'd have to go back to my testimony to give you complete and accurate details. But those are, let's see, if I look at what SPS requested, appeal of the commission's order, property tax tracker, I don't see anything that has to do with the Energy Transition Act and retirements or such, which, if I'm accurate, those are going to be one-time costs.
Okay. Looking at your testimony in support of the comprehensive stipulation, the revenue requirement that was settled upon in the stipulation is relatively close to staff's recommended revenue requirement deficiency number, isn't it, Ms. Daschino?
That's correct. There's a 3.9 million reduction from what staff recommended.
Did that give you some comfort to support the stipulation?
It did, and I believe the stipulation reflected staff's concerns.
And you indicate in your testimony on page 2, going on to line 3, with regard to the unspecified adjustment to the revenue deficiency of $8,675,546.
I'm sorry, give the number again. It is a revenue.
The unspecified adjustment in the amount of $8,675,546. Your testimony at line 20. The parties work to keep the unspecified adjustment to the revenue deficiency palatable and rather reflect visible adjustments through the stipulation. That's your testimony?
That is my testimony.
What does that mean?
Well, we wanted to flush out as much issues as possible, and visual means if you look at rate case expenses, for example, you can see the numbers that we agreed to versus having those in the unspecified adjustment and that number amounting to 10 million. Or the cash working capital, including that in that number, making it 12 million. So then we have less certainty of what adjustments were actually made in the stipulation. So as best we could, we tried to identify everything for the commission to consider, and we were left with that number of unspecified adjustments.
So then the goal, at least for, or one of the goals, then for staff is to try to make as many to assign a specific number to as many of the issues as possible and have as small amount as possible included in the unspecified adjustment?
Yes, and I believe all the signatories as well. I won't speak for them, but that was our intention.
you've referenced just now and then further on in your testimony, the rate case expenses, and part of the agreement was that the signatories agreed to the recovery of the rate case expenses in the amount of $2 million. The application had requested 3.6, and staff believes that this particular agreed upon amount, you say the stipulation shows agreement amongst the signatories to come to a fair recovery of costs. So am I to take from your testimony that staff believes that the $2 million rate case expense number is a fair recovery of costs?
Yes, that is accurate. Our total rate case expenses that we put into the revenue requirement were 2,007,130. So 7,130 was omitted in that adjustment, but the revenue requirement was still lower than what staff filed. So that give and take was there.
Is there any true up on that $2 million rate case expense? If the commission, well, if the commission were to grant the stipulation and said, okay, you get $2 million, do they have to file anything else?
I think what the stipulation states is if they exceed it, they won't recover it, but I don't want to. I would like to look at that to verify if I can pull it up. A Dropbox is not okay. One thing I would like to note though is in this filing of rate case expenses, SPS did exceed what they were allowed from the last rate case, and I believe it's in Naomi's testimony, Naomi Velasquez, what we did with that. So page
Ms. Dashian, are you still looking?
Yes, let's see. Okay, page 5 of the stipulation, yes, section 6. The stipulated base rate increase includes recovery of $2 million in rate case expenses to be amortized over 2 years. If rates in SPS's next base rate case take effect prior to full recovery of the $2 million, the unamortized costs from this case will not be recovered from customers.
Okay, so it's contingent on another case.
Correct.
Okay. You're aware that SPS has been filing rate cases approximately every 2 years?
Yes.
For at least the past 6 years?
Yes.
And each of those rate cases has rate cases expenses of somewhere between $1.5 million or more.
Correct.
Each of those cases has been settled by stipulation where SPS has agreed to take less of a revenue requirement increase than it claimed in its original application.
That is correct. to my knowledge.
Do you think that it might be better off, at least as far as the rate case expense, if perhaps the rate cases were filed less frequently?
Well, it depends on the needs of the company. I wouldn't want to speak for them on why they need to file the cases as frequently as they do. And staff is aware of these rate case expenses and they're analyzed in each case. And through analyzation, I mean, there are expenses that we do exclude based on justifications that are not included in my testimony, but it's not a just pass for SPS to come in and file their rate case.
It is not just a
pass for them to come in and include the rate case expenses in the revenue requirement, and staff does analyze their expenses pretty thoroughly.
And I'm not suggesting that staff's giving SPS a pass, Ms. Dashino.
Right.
I'm just wondering whether or not whether or not staff has thought about perhaps in analyzing what might be in the public interest, about whether or not it might be in the public interest if, rather than coming in every couple of years, perhaps during negotiation of a stipulation or in a potential litigated case, you know, whether or not staff ever thinks, well, you know what, perhaps if they were given more in the revenue requirement or in this area or that area, then we wouldn't be incurring $2 million of rate case expenses that the ratepayers have to pay.
To speak on behalf of myself, my opinion is that, you know, the company comes in as necessary. The industry is always changing. And while yes, I would love to see customers avoid as much cost as possible, I don't believe it's up to staff to make that determination about when SPS comes in. Granted that we are in agreement with the cost that they've presented, I don't see an issue or including a stay out if we are comfortable with the cost they've included in their revenue requirement. And in 2 years, they come in and they have additional costs to include. I just don't feel that judgment can be made by staff.
And staff doesn't include it in its analysis of the public interest.
Staff analyzes the revenue requirement that is presented and does its best to consider the public interest.
Okay. In further on in your testimony on page 4, regarding the subject of the NOx allowance and the agreement in the stipulation that they can be covered through the fuel clause. Do you know whether or not El Paso Electric and or PNM recover any NOx allowances through the fuel clause or some other method?
I do not.
Mr. Bagatko, consider that a bench request.
Yes, Madam Hearing Examiner, and the substance of that would be whether and to what extent the other two big IOUs run NOx allowances through their fuel clauses, correct?
Or how how those costs, if they are incurred, are collected by those two companies.
Thank you.
Thank you. Ms. Stashino, you're familiar with the issue regarding the liquidated damages?
Yes,
And that issue was not specifically settled through the stipulation, was it?
I don't believe so.
Do you know how or if the issue of liquidated damages has been treated by the commission previously?
I do not.
Mr. Bagatko,
Yes,
consider that a bench request. Like to know whether or not there's any reference, any precedent for treatment of liquidated damages by the commission regarding a utility. Payment to a utility.
all right, noted. Thank you, Madam Hearing Examiner.
Thank you. Ms. Dashino, I believe that's all the questions I have for you. Thank you very much. I believe that at least one of the commissioners has questions for you.
Okay.
Mr. Commissioner Ellison, you have questions for Ms. Dashino?
Yes, I do.
Thank you, sir. Go ahead.
Hi, Ms. Stashino. Good morning.
Morning, Commissioner.
I wanted to ask a few questions. You were speaking with Hearing Examiner Hurst just now about what went into your initial roughly $37 million required revenue recommendation. I was wondering if you've done a reconciliation table showing the differences between that initial SPS number of about 76 million and your 37 million.
No, as I stated, is to show the reduction in how we made our adjustments from the 76 to the 36. Is that?
Yes.
Okay, initially I had, and if you would like that, I would not have an issue with completing that by end of day.
I would like a reconciliation table. I noticed that Kevin Higgins, I'm not sure if you reviewed his testimony. He had a nice reconciliation table showing the difference between the company requested 76 million and how he got to his roughly 1 million required revenue number. And Andrea Crane had something like that as well. So could we please consider that a request?
Commissioner Ellison, that will be bench request to staff. Ms. Dashino, you understand the table that Commissioner Ellison would like you to?
Yes.
Very well. Go ahead, sir.
Great. Another question in looking at Stephanie Niemi's testimony, she talks about that starting with case 15296, that SPS began using a server-based software program called RIS. And she says specifically to calculate the revenue requirement rather than the spreadsheet-based methods used prior to that case. Are you familiar with this RIS system?
I am not. SPS provides us their cost of jurisdictional and cost of service via Excel.
Okay. Yeah, I guess, that's on, page 18 of the PDF of her testimony. So that's something that you did not have access to, is that correct?
That is correct.
Okay. Yeah, I find that interesting. So you did have access to a spreadsheet that allowed you to calculate the revenue requirement. Is that correct?
That's correct.
Okay, and that was SPS provided
That's
spreadsheet?
correct. Yes.
Okay. And is that the spreadsheet that you used when you made adjustments and wanted to see what how the revenue requirement would change?
That is correct.
Okay. What are your thoughts about the use of a future test year in a rate case? Is this something that SPS has requested previously?
I believe they requested one previously, but it wasn't, I think that case got dismissed. Previously to this one, it was a historical test year. So this would be the first future test year that I have worked on with SPS. And I feel that this case in particular, it was a good idea to use the future test year. I know they're working on their IRP right now, and they might be incurring some costs. And they may be back in sooner than, in a couple of years as well. So I think in allowing that, they're able to recoup the costs that they incur.
And so, so you're saying you support the, this concept of using a future test year for this case?
I do.
I guess, Andrea Crane pointed out that, there is an inherent issue when you use a future test year, that some of the amounts are going to be more speculative as compared to a historical test year. Would you agree with that?
I think that in either case, they could be speculative. I mean, the historical test year looks, by the time rates go into effect, I would say 2 years back, and costs may have changed by that time, and project may not have been completed, may have been completed. I think it's the same in both ways. I don't think there's exact certainty in the test years.
But wouldn't you say with the historical test year, at least that these amounts were spent, as opposed to the future test year, it involves some projections around what the company thinks might be spent?
But I mean, the cost did incur, but that doesn't mean that when the rates go into effect that those costs are completely accurate either. So I just feel that it's always a give and take when they're filing these, and when they come in for their next rate case, we are going to evaluate those costs and were they incurred or were they not in either instance. So I think that either way, the utilities are just focused on getting the best recovery for what they expend.
One reason given by SPS for why filings have been so frequent is because the historical year was used. I believe that was Ms. Trammell who stated that. Is that correct?
I don't recall. I'd have to go back and look at her testimony.
Okay. But did that issue ever come up that having a historical test year is one reason why the company's rate case filings have been so frequent?
I don't recall having that discussion.
Okay. I guess I'm just wondering if that's true, and if using a future test year would seem to suggest that there would be less frequent filings. Could something like that be a part of a stipulation, some agreement, not to have a filing every 2 years?
It could be. It just was not a part of this stipulation, but I believe I've seen it in prior stipulations.
Okay. I believe it was page 11 of your direct testimony, you were opposing removing the NOx caps until SPS has proven they have taken steps to limit NOx emissions. Could you clarify what kind of steps you were looking for them to take?
Well, I think in my testimony at page 11, I give the example that SPS had purchased power agreements with Roswell and Travis solar energy centers, and they provide energy without NOx emissions to SPS retail customers, but Texas has rejected these resources and they're assigned to New Mexico, which reduces the NOx allowances that should be allocated to New Mexico. But in consideration of the stipulation, we agreed to remove that cap and allow them into the FPPCAC with the knowledge, at least on staff's end, with the knowledge that they will be filing a continuation FPPCAC this year. And we'll have 4 years of reconciled costs in that FPPCAC to review, or should the commission choose to review those sooner, there is a provision in the rule, and it's 17.9.550.14 that allows the commission to review the cost in the FPPCAC. So when we considered that in the stipulation, it was within the constraints of the field clause.
Okay, I guess my question is, it just seemed like to me those were two different things. The steps to limit NOx emissions overall versus maybe an allocation of NOx, emissions costs between Texas and New Mexico.
Right, it was meant to be more of evaluate the allocation.
More of how it's allocated. So wouldn't the fact that the New Mexico jurisdiction has a somewhat different, sources for, I guess contractual sources for purchased power. Wouldn't that be taken into account in allocating the NOx emissions costs?
It was something that I recommended to the commission to review if they so desired. I mean, currently in the fuel clause, New Mexico's retail allocator is 0.43%. And I believe that's what would be applied to these NOx allowances through agreed upon in the stipulation. And I mean, this was my direct testimony, and in adopting the stipulation, as I mentioned, staff evaluated the FPPCAC and was comfortable with making the recommendation and supporting the stipulation for the NOx allowances.
But has staff been able to review this, since you raised the issue of the allocation of the NOx emissions costs between jurisdictions? Have you been able to review how SPS is currently performing that jurisdictional allocation?
Staff has not done an analysis for that.
Okay. Another thing you mentioned in your testimony is historic attachment Z2. Could you please explain to me what that is?
Okay. Those costs, I don't have complete familiarity with them. I just know they were included in the cost of service study, and what they were allowed in the last rate case were 4 years of amortization, which would be complete by the time rates go into effect in this case. So there would be no collection for those moving forward. From an accounting standpoint, that's the analysis I did.
Okay, I was just wondering, what is it? But it looks like
I'd have to go back to the cases and to get a better accurate description for you, Commissioner.
Okay. Let's see. Another question is, you mentioned on page 16 that staff would like to note it maintains its position on legacy meters pending the outcome of SPS's grid modernization filing. What is staff's position on legacy meters?
As filed in the grid modernization, we would like those legacy meters removed from rates.
You mean when and if the grid modernization application is approved?
Depending on the final order in that case, that's correct.
So if the legacy meters are retired due to a possible approval of the grid mod plan, you're saying that the undepreciated balance on those meters should be removed from the rate base?
That's correct.
Okay. That's fine. One question about the rate case costs, I guess following up on the hearing examiner's questions, the stipulation caps the cost at $2 million. Can the company come back in the next rate case and say, oh, we spent more than that and we want to recover those excess amounts?
I don't believe the stipulation allows for that. I believe it's the 2 million, and if they did not recoup it all, by the next rate case they file, they won't recover what they've lost. And I'm guessing it's not in the stipulation, but if they're not going to be allowed to recover what they didn't collect, I wouldn't believe they should be allowed to recover anything above what was stipulated to.
In the previous case, stipulated case with SPS, an amount was agreed to, and didn't they say, that they've spent more than that, and didn't they request that amount in this rate case?
They did. My understanding is they left it out of the revenue requirement, but staff did that analysis, and I believe in the testimony of Naomi Velasquez, it was not allowed. A 30% was allowed, but it wasn't justified completely. The cost behind those, not the cost, the records behind it, I should state, that we didn't feel there was enough evidence submitted to support those
I
costs.
see. But doesn't the whole idea of, reaching an agreement on rate case costs and then coming back in the next rate case and saying we spent more than that, doesn't that sort of defeat the whole idea behind, reaching a stipulated agreement on rate case costs?
Well, I believe in this stipulation, we account for not going over the 2 million, but I believe in the previous stipulation, and I don't have it right in front of me, there was an agreement to allow them to ask for the complete recovery of what they incurred. So the two stipulations are different in that aspect.
I see. And you mentioned to the hearing examiner that it's staff's aim to get those unspecified adjustments as low as possible. Do you feel that the 8.7 million is a good outcome in that regard?
I feel it is, mostly because our position that we initially came in is higher than what we settled on, first of all. And like I said, we tried, not just staff, but all the signatories tried to flush out as much as possible for the commission to review instead of include in that unspecified adjustment. And we were comfortable with that number.
I see. Well, I appreciate your work on this case, and thank you for answering my questions.
Thank you, Commissioner.
I don't believe that we have any other questions for Ms. Dacheneau. Mr. Bagatko, any redirect for Ms. Dacheneau?
Madam Hearing Examiner, in this instance, I don't think any redirect is necessary, but I would have one point of clarification regarding the 3 bench requests that are clustering around Ms. Dacheneau. I know she indicated that she could have the reconciliation probably done by the end of the day, but in the event that we get spread a little thin, is there an ultimate deadline you might suggest for all 3, perhaps in the next couple days?
Well, time is of the essence, Mr. Bagatko. So as soon as possible would be good, especially knowing that any response to the bench request that I can't actually get admitted into the record, I'm not going to have the party's position on whether or not they're potentially willing to waive any opportunity to file a response to.
Fair enough.
So, if staff, hopefully Ms. Dacheneau can work on bench request 12, and and perhaps someone else in utilities can work on the Knox question, and perhaps someone else in legal can work on liquidated damages, and just use your best efforts, Mr. Bagatko.
Madam Hearing Examiner, we'll put the do it to it. And just so I understand, then these should be styled as responses to bench requests 12, 11, and 10.
Yes, sir. I believe
Thank you.
that's correct.
Thank you.
Thank you. And anyone have questions for Ms. Dashino? Hearing none. Ms. Dashino, thank you so much. You're excused.
Thank you, Madam Hearing Examiner.
Mr. Bagatko, let's see. Mr. Lee, shall we take a recess at this point?
Yes, please.
Very well. It's 10:30. We'll come back at 10:40 and we'll hear Mr. Bagatko from Mr. Sidler.
Okay.
All right.
Thank you.
Thank you.
Thank you.
Hey, Mr. Lee, how are we doing?
Good, Judge.
Awesome. Great. Well, actually, we have 2 minutes left. Okay, I think we are returning from our morning recess. I would like the record to reflect that we are I've just been downstairs to records and I was handed Sierra Club Exhibit 2 confidential, which had been retrieved from the record warehouse. I opened up the Sierra Club Exhibit 2 confidential because it was too fat to fit into the shredder. I thought it was just the pages of the confidential testimony. That was inaccurate. It was all of Ms. Glick's testimony was on pink paper. I fed it into the shredder, even the envelope, except for the metal clasp. It has been destroyed. Does that suffice, Ms. Hardy?
Yes, it does, Your Honor. Thank you.
And if was witnessed from a distance of about 5 feet from Ms. Sandoval, the Bureau Chief of Records, who did not see what was actually on the documents, but saw what I was doing. Okay, great. Mr. Bagatko?
Madam Hearing Examiner, before we get to Mr. Sidler, just to be clear, do we have a determination yet regarding Ms. Velasquez, whether or not we will move her testimony in by stipulation, or if you still want her to come and sit on the stand?
I don't have questions for Ms. Velasquez. I don't know if any of the commissioners have questions for Ms. Velasquez. I believe her testimony can be stipulated in, Mr. Bagatko.
And when would you like to do that, Madam Hearing Examiner?
We could do that now if you're ready.
I can do that. Thank you.
Go ahead.
Madam Hearing Examiner, in conformance with our practice in this case regarding the admission by stipulation of testimony for which there are no questions from you, Madam Hearing Examiner, or the commissioners or any of the parties, I would move for the admission of the prepared testimony of Naomi Velasquez into the record. And that's what she filed in this case on April 21st, 2023. It's been provisionally marked as Staff Exhibit 5. It is the version that was uploaded to Dropbox and presumably downloaded and accessible by others. And it does carry Exhibit NAV1, Exhibit NAV2, and an affirmation from Ms. Velasquez affirming the accuracy and contents of her prepared direct testimony. And so with that, I would move for admission by stipulation into the evidentiary record of Staff Exhibit 5, Ms. Velasquez's prepared direct testimony, please.
And Mr. Begacco, it does meet all of the requirements for having to be stipulated into the record.
Yes, it does, Madam Hearing Examiner.
Very well. Any objection to what's been identified as Staff Exhibit 5? Ms. Velasquez direct testimony as placed into the Dropbox by staff. Hearing no objection, Ms. Velasquez appearance is waived and Staff Exhibit 5 is admitted. Mr. Begacco?
Thank you for that, Madam Hearing Examiner. And with that, I would call Mr. Jack Sidler to the stand.
And I see Mr. Sidler. Good morning, sir.
Good morning.
Mr. Lee, would you please swear in the witness?
Yes, Your Honor. Mr. Sidler, would you raise your hand? Do you solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, nothing but the truth?
I do.
Thank you, sir.
Thank you, Mr. Lee. Mr. Begacco?
Madam Hearing Examiner, thank you. Good morning, Mr. Sidler. How are you?
Good morning. I'm fine.
All right, if you'll bear with me, we have a couple of items to try to move into the evidentiary record, and they consist of your prepared direct testimony filed in this case on April 21st, provisionally marked as Staff Exhibit 6, and then your testimony in support of the stipulation, provisionally marked as Staff Exhibit 7. I'll start with Staff Exhibit 6, and I trust and hope that you have a copy of that in front of you, Mr. Sidler.
I do.
Would you please take a moment, Mr. Sidler, and flip through Staff Exhibit 6 to make sure that it is a complete and accurate rendition of what you caused to be filed in this case on April 21st, 2023.
Okay, it appears to be complete and accurate.
Thank you. Madam Hearing Examiner, do you still hear and see me?
I do. But you're frozen.
Did I go off the record, Judge?
Yes. Mr. Friedman, are you nearby, Mr. Begacco?
I am not, but I'll be reaching out to him, see if he needs me to take over. Let's see here.
Let's recess for just a minute. You're frozen. Okay. Do you think I need to go downstairs? Do you think it's your unit or you think it's IT? Okay.
Judge, you're not muted.
Okay. Hey, thanks, Mr. Lee. That knock at the door was Mr. Begacco. His computer has crashed. Let's take a 5-minute recess and allow the computer time to reboot. I've got 10 till, let's come back at 11:55.
10:55?
10:55. Thank you. Mr. Fiddler, I believe you're going to have Mr. Regatko back.
I think I just saw him.
There he is.
Hey, hopefully everything's good now.
All right. Well, we've got one more minute on our recess. Okay, we are back from our recess. And Mr. Regatko's technology problems, I believe, have been fixed. And let the record please reflect that we have much appreciation for Phil in IT. Phil, you're probably not listening to us, but thank you, Phil.
I thank Phil too. I second that. I'm back from the blue screen of near-death computer experience. And are we back on the record and ready to roll?
We
Yes,
are
sir.
ready on the record, sir. So I believe you had Mr. Sidler look at Staff Exhibit 6, and he had affirmed that it was a complete copy of his direct testimony.
Correct. I did at least hear him say that before I cut out completely. So thank you for that.
Go ahead.
All right, Mr. Sidler. Then following on that last question, let me regather my wits here. It is a complete and accurate copy. I believe you just indicated that before my interruption. I also understand that this was prepared by you or under your direct supervision. Is that correct?
That's correct.
And that would include the sole attachment to this prepared direct testimony, which I believe is an appendix that lists your cases you've testified in here at the commission, correct?
That's correct.
And I understand also that you do not have any corrections or typos to address in this prepared direct testimony. Is that
That's
accurate?
correct. That's accurate.
Thank you. And Mr. Sidler, I guess finally then, the answers we see to in all those questions posed in your prepared direct testimony, would they remain the same today here at this public hearing, or would you have cause to modify any of those?
The answers would remain the same to those questions, yes.
Okay. Well, with that, Madam Hearing Examiner, trying to get back up onto my tempo and pace, I would move for the admission of Mr. Sidler's prepared direct testimony marked as Staff Exhibit 6 into the evidentiary record for this proceeding.
And Mr. Regatko, this is the version that was placed in the Dropbox.
That is correct, Madam Hearing Examiner. Thank you for that.
Any objection to what's been identified as Staff Exhibit 6? Mr. Sidler's direct testimony as verified by him here today and as placed in the Dropbox. Hearing no objection, Staff Exhibit 6 is admitted.
Thank you. Well, moving along, Mr. Sidler, now let's address your testimony in support of the stipulation, which I believe you caused to be filed in this case on May 26th. And I trust and hope you have a copy in front of you of that item.
I do.
And as I said before, this has been provisionally marked as Staff Exhibit 7. So same as last time, if you would you please flip through that to make sure it is a complete and accurate rendition of your testimony in support of the stipulation.
It looks complete and accurate.
Thank you for that, Mr. Sidler. And again, this was prepared by you or under your direct supervision, including the appendix of your cases you've testified in. Is that correct?
That's correct.
This is the version that was uploaded and presumably downloaded by you from Dropbox. Does that meet with your recollection?
That's correct. That's where I got this from.
Thank you, Mr. Sidler. And then finally, Mr. Sidler, as we sit to here today in this public hearing, if you were asked the same questions as we see posed there in your testimony in support of the stipulation, would your answers to those questions change from what we see in that pre-filed document, or would they be the same?
They'd be the same.
All right. Thank you very much, Mr. Sidler. Madam Hearing Examiner, with that, I would move for the admission of Mr. Sidler's testimony in support of the stipulation into the evidentiary record, and it has been marked as Staff Exhibit 7.
Thank you, Mr. Bagacco. Any objection to what's been identified as Staff Exhibit 7? Mr. Sidler's testimony in support of the contested stipulation as verified by him here today and as placed in the Dropbox. Hearing no objection, Staff Exhibit 7 is admitted. Mr. Bagacco.
Madam Hearing Examiner, thank you for that. And I understand that there is no cross scheduled for Mr. Sidler, but that you and one or more commissioners may have questions for him. So I tender Mr. Sidler for that examination.
Thank you, Mr. Bagacco. I
Thank
do
you.
have a few, I have a few questions for you, Mr. Sidler. Good morning. Welcome to the hearing.
Good morning. Thank you.
Your area of responsibility, as indicated in your testimony, primarily have to do with the depreciation rates, abandonment of certain plant, and the extension of lives being proposed by SPS, correct?
That's correct.
And just for background purposes, Mr. Sidler, can you tell the commission how you review the particular plant? In other words, do you actually go out and do inspections of the generation plant when there are requests to retire it?
No, I do not in general. I mean, I have toured a lot of plants in years past, but not from the standpoint of inspecting it for retirement.
So then essentially the recommendations that you make on generation assets is based upon a paper review?
That's correct.
And as it pertains to this particular case, SPS has requested that Plant X units 1 and 2 be retired.
That's correct.
And also along with that, that Cunningham Unit 1 also be retired. Is that correct?
That's also correct.
And in your review of whether or not you agreed with whether or not those particular plants should be retired, you indicate in your testimony that all 3 of those plants, I believe, began commercial operation back in the 50s.
Yes, all 3 of those plants are actually older than I am. They're back in 52, 53, and 57, I believe.
And when plants are of a certain vintage, especially if they are gas-fired steam plants, do they develop some issues that make them less efficient than, say, a new plant?
I would expect that they do unless they're very heavily maintained and have a lot of parts replaced. But I believe that it gets to a point where it's cost more to replace parts than the plant's worth. Similar to most mechanical devices.
Okay, and I note on page 4 of your direct testimony, at beginning on line 3, where you are going into your recommendations, you say staff also recommends that the commission recognize the issue of SPS's extraordinarily high energy losses on its distribution system and require SPS to file a plan for identifying the causes of these high energy losses. Is that correct?
That's correct.
What are you referring to when you're talking about a high energy loss?
That's basically losses on the transmission system. From point A to point B, you'll never transfer 100% of the energy. There will always be losses on those lines due to resistance, capacitance, inductance, things like that. And that's what those losses appeared to be higher than the number of utilities around.
Okay, so that's a separate subject than the retirement of Plan X 1 and 2 in Cunningham, correct?
Yes, that's correct.
But in addition to the cost to maintain the units, isn't there also the issue of what SPS refers to as a high heat rate?
That's true, and that's generally built into the plant. That's the efficiency that it converts the gas burned into electricity generated. The higher the heat rate in MMBTUs is worse, because heat rate is MMBTUs over kilowatt. So the higher that number, the worse, the less efficient the plant is.
Okay. And that also would be a reason, wouldn't it, Mr. Sidler, to consider either curtailment or abandonment of a particular plant?
That's correct. Abandoning the plant is good. Eventually, heat rates will eventually go up as the plant ages. But unless it's extremely well maintained with a lot of new parts put in and things like that. And the higher the heat rate, the more expensive it is to generate electricity. And at some point, it just goes to being too much, more expensive than it's worth.
Okay. And you've indicated in your direct testimony, beginning on page 7, you've indicated the standards that the commission usually looks at when considering abandonment of a plan, referring to on page 7 the commuter committee factors.
Yes, ma'am, I do.
And you believe that SPS has filed sufficient evidence to meet those standards as necessary for you to recommend that that the 2 Plan X and the Cunningham unit be abandoned this year, correct?
Yes, I do.
And you also are in agreement. Did they present any costs associated with that abandonment?
I don't recall that they've presented any specific costs, at least not in the engineering and testimonies that I read.
Is there a chance, like some of the other plant that seems to be requested to be abandoned, and then the utility changes their mind later? Do you think that potentially could happen with these three plants?
I don't believe so.
Do you know whether?
I
Go
believe
ahead,
at
sir.
one point that they had requested abandonment and then backed off because the price of gas was so cheap that it was cheaper to run those plants than to run some other plant. So they wanted to keep those plants going as long as the gas was cheap, and I don't believe that's the circumstance anymore.
Okay. So you think that then potentially that these three plants actually will be abandoned this year?
I believe so.
Additionally, so that refers to Section 3 of the stipulation, which says Plant X Unit 1, Plant X Unit 2, and Cunningham Unit 1. The date of abandonment and retirement of those three units will occur on or before December 31st, 2023, correct?
That's correct.
Okay, so that's actually been agreed to by all the signatories to the stipulation, correct?
That is correct.
Are you aware what if there was any testimony by any of the other parties in this case that objected to the retirement of these three plants?
I'm not aware of any.
Okay. And then with regard to the Section 4 of the stipulation, and that pertains to Nichols Units 1 and 2, and that says the service lives of Nichols Unit 1 and 2 are extended to 2028 and 2027 respectively. Is that correct?
That's correct.
And what was the purpose for the extension of the lives in those two plants?
The reason for the extension of those lives was given as that they are able to be run in response to renewable energy. They can be ramped up and down fairly readily as the renewable energy appears and disappears. So they wanted to hang on to those plants a few more years to give themselves basically a backup and cushion.
A backup and
Cushion.
thank you.
And Mr. Fiddler, are those also gas plants?
Those are gas plants. To the best of my knowledge, they are.
And do you recall when their original I believe in your testimony on page 4, you say that their service lives are being extended from last year and this year. So 5 years for those plants, correct?
That's correct. They want to basically add 5 years to the lives of those plants.
Okay. And do you know whether or not anybody filed any testimony that objected to those requests?
I'm not aware of any.
And you've recommended that should also occur?
I recommend that, yes, ma'am.
And then finally, in your testimony, well, not finally, but you also are in agreement with Section 2 of the stipulation, the date of abandonment and retirement of Tolk will be set at December 31st, 2028.
I agree with that.
And that is a reduction, since it's currently set to be abandoned in 2032.
That's correct. The current date's 2032. They're asking to move it to 2028.
And did you, in your consideration of changing the request to change the abandonment date, did you review any of or consider the claims that are being made by CCAE, who is objecting to the stipulation with regard to any type of negative effect that this might have?
I didn't really review or analyze the claims by CCAE in objection to the stipulation. No.
Well, in your evaluation of whether or not, or did you evaluate the section of the stipulation regarding section 17, the self-commitment of TOLC, and the testimony that we've heard considering the modification of the TOLC operation plan? Did you consider those in your abandonment evaluation?
I looked at that, and that was basically an agreement by SPS to limit their commitment of TOLC to the Southwest Power Pool's day-ahead markets, except for cases of required testing where they might have to run the plant for a period of time to test repairs or test modification, and they'd have to have somewhere to put that generation. And it also deals with reliability concerns or safety concerns of whether they run the plant and commit to SPP. You know, basically, they're not going to commit the output of that plant to SPP to the day ahead market, except for those three reasons.
But did you have any consideration in your evaluation for abandonment with regard to any negative effects that potentially changing the way that TOLC is operated now compared to how it might be operated in the future?
I do not have any real issues with a change in, with a negative change in operation. You know, they've had varying operational changes because of other limitations with TOLC, and I don't believe that this is going to be any kind of a negative effect.
In looking at your testimony in support of the stipulation, Mr. Sidler, on page 3, you're addressing paragraph 7 of the stipulation. Subparagraph 7. Which It says SPS's request to defer incremental O&M costs associated with the continued flexible dispatch of tolk and to record a regulatory asset for recovery in a future rate case is withdrawn. The signatories agreed that the estimated incremental operation and maintenance expense associated with continued flexible dispatch of tolk of $980,823 is reasonable, and this amount is included in SPS's base rates.
Yes, I agree with that from the standpoint that that allows them some flexibility for routine maintenance of the plant, but it doesn't allow them to do extraordinary maintenance on a plant that's going to close in essentially 5 years.
Yeah.
So almost $1 billion is for regular maintenance.
I believe that that's what the intent is, that, you know, that there could be, that they won't charge any more than that, which will preclude major repairs. That wouldn't
Okay.
allow them to, that wouldn't allow them to add some sort of emissions control or thing that just basically allows them to maintain what's there.
Okay, so you actually reviewed the costs that they were proposing for expenses.
I didn't review specific costs. No, I just believe that that was a reasonable number. That they have to be given some leeway to be able to do maintenance type of operations. But not do any kind of, you know, extensive modifications or repairs.
Very well, sir. And then section 5 of the stipulation is entitled depreciation rates, and it says depreciation rates are stated in Exhibit C to the stipulation, and the depreciation expense component is $10 million. And this is an approximate 6.9 million New Mexico retail decrease in depreciation expense from the rebuttal revenue deficiency. You testify on page 4 of your stipulation testimony that you believe that the new depreciation rates contained in Exhibit C should be accepted.
I believe that, yes.
Why?
Well, anytime you change depreciation, you do change the rates charged to depreciation. The rates themselves are actually worked into the testimonies in basically the accounting testimonies from the accounting bureau, but in the exact dollar numbers, but there are changes. They are changing the end dates of the plants. There are changes from what the old depreciation was to the new. And that I don't see any real major issues with it.
Additionally, Mr. Sidler, on page 8 or page 5 of your stipulation testimony, you're addressing item 16 of the stipulation with regard to SPS's integrated resource planning process. And in your testimony, you say that the timing of the replacement resources needed to address the retirement of tolk and SPS's other needs and other SPS needs to be addressed in the current ongoing IRP process. And that you agree with that, correct?
I do agree with that. I feel that that kind of information is at least partly what the IRP is for. They do have an IRP process going right now concurrently with this case. And I believe that that's the correct place to determine those things.
And are you participating in that process?
Yes, the IRPs are officially being handled, I believe, by our utility division director, Ed Rilkoff, as well as a contractor consultant. But I have been participating in these, yes.
With your recommendations regarding abandonment, extension of service life, reduction of service life, do you have any concerns, Mr. Sidler, that SPS is not going to be able to have enough capacity to meet its requirements for its customers?
I don't have any concerns along those lines, no. I mean, I believe they have enough other generation coverage. They're members of the SPP, so they can always buy power through the SPP as the need arises.
But you're okay with the timing between not having new resources approved at the time of the abandonment and or changes to generation asset service lives, that it's a prospective process for new generation, along with the testimony from SPS witnesses regarding increase to the reserve margin as required by SPP, and then downgrading or change of accreditation of capacity for renewables?
I don't have any concerns that way. I believe that, within the timing of these retirements and that they can replace the power they need to, and they can always buy power from SPP through their day-ahead market as needs arise.
In your testimony on page 5, in support of the stipulation, Mr. Sidler, you recommended that the stipulation approval of the issues you've addressed be approved. You've also requested or suggested that SPS be required to file a notice, in this case, for each plant abandoned and retired as a result of this case within 1 month of retirement. Is that correct?
That's correct, ma'am.
Why?
So that there's a formal record that these plants have been retired as they requested in this case.
Was that specifically included in the stipulation?
No, it wasn't, I don't believe.
Do you know whether or not it was accepted by SPS?
I'm not aware that it was or wasn't.
So you're asking, in addition to approval of the stipulation, that staff require SPS to file this notice?
I guess that's a way to look at it, yes.
Okay, should I be looking at it a different way?
Not that I can think of.
Additionally, your concerns, Mr. Sidler, regarding the line loss issue that you believe that SPS had, has the stipulation assuaged those concerns?
The stipulation doesn't address any issues regarding the line loss at all. But SPS witness Ripberger did provide, I think, an excellent response to those issues as to why those numbers were the way they are.
And can you summarize what he told you that perhaps informed you?
It was in his rebuttal testimony in this case. Basically, he just went through what issues affected line loss and why they were a case in this area. They're very rural transmission lines, and there's varying ways that they can build them. You know, and of course, the better they build them, the more expensive they are. So they've sort of tried to mitigate cost versus operation. But the numbers that I based the original thing on were not adjusted for those issues. They were just straight off the board looking at them.
Well, do you have less of a concern now after seeing Mr. Ripperger's rebuttal testimonies?
Yes, my concern is far less now than it was prior to his rebuttal testimony.
Very well. Thank you, sir. I believe that's all the questions that I had for you. Appreciate your time.
Madam Hearing Examiner, I do have just a couple of questions.
Very well. Commissioner Aguilara, please go ahead, sir.
Mr. Sidler, thank you for your testimony and for your appearance here. The hearing examiner was asking about the same issue that I had questions about with respect to what you refer to as extraordinarily high energy losses. And so thank you for your responses to her questions. I think that eliminates some of the questions that I had. But you explained in your initial testimony that SPS has high energy losses, especially as compared to Public Service Company of New Mexico and El Paso Electric. And you discussed that SPS should correct the issues and bring the energy losses in line with PNM and EPE. And so I just listened to your response about SPS having more rural lines and that there are various ways that they can be built. And so these, there's sort of a trade-off between mitigating the cost and the operation. Can we drill down a little bit further on that? In your opinion, I guess if we can back up, what is it that you were looking for in your initial testimony when you were suggesting that SPS should correct the issue?
Well, initially I was looking at the data that was just raw data that was just that these numbers just seem way high compared to other utilities, especially PNM and EPE, without taking into consideration any of the reasons why. And Mr. Ripberger pointed out in his rebuttal testimony that part of it is EPE and PNM have more urban systems than SPS does in that area of New Mexico. And that it would just cost, it would cost more money to, to build their lines to try to equal those line losses. And that there was a point where, where the cost and the benefit was not necessarily worthwhile.
Okay, thank you. I have a couple of questions based on that response. One of them is whether there is a way to compare rural lines with rural lines, right? So where maybe there's a more accurate comparison there. And then the other thing is, I just want to pinpoint what about SPS's lines is creating higher energy losses. Like what is it that they would, that would cost more, presumably, that they could fix or not redo the lines, but reconductor the lines maybe, or make upgrades to the lines.
Well, I'm not really sure how you would compare rural versus urban builds, but I mean, some of the differences would be in wire size.
Okay.
The bigger the wire you use, the less resistance it has, so longer runs don't use up as much, don't have as much energy loss through resistance. However, the bigger wire costs more money.
Mm-hmm.
And I can't put a price on that because I don't know what the difference in cost of wire is. Or things like that, but SPS is trying to keep the cost of their systems down, for their customers.
Okay. Yeah, I appreciate that, there is a trade-off there, as there is with many things. And then for the record, can you explain just, the data that you were looking at and explain for the record what the losses are for P&M and EP as compared to SPS?
Well, I believe that in my direct testimony, there's a table. Let me get to it.
Is it figure 1 on page 12?
Figure 1 shows some of the differences. That's correct.
Yeah.
P&M, EPE, and SPS are in there. But going down to, I believe it's table 1 on page 14. It does show SPS losses versus P&M and El Paso losses in that table.
Okay, so I'll just, point out for the record here. So what I'm seeing on table 1, which is on page 14 of your initial testimony, P&M primary energy loss percentage is 1.55%. EP primary energy loss percentage is 2.04%. SPS primary energy loss percentage is 5.6, 5.7%. It seems like, quite a difference. I guess my question is, I'm sure there is a way to compare this, even if P&M and EP have more urban areas and the type of wires that are being used, for example, are of a different grade and perhaps better at avoiding as much losses. But I'm sure there are other utilities elsewhere that, especially in the West, that are very rural, and I'm wondering whether we can compare those losses, just because there does seem to be a big difference as compared to EP and PNM. Is there a way to to look at other utilities and perhaps compare the type of lines, compare SPS's system to maybe one in the West that is similar to SPS?
I'm not aware of any easy way to compare them because we're not familiar with the other utilities at all. PNM, EPE, and SPS we deal with, but other utilities we don't. And in an urban situation, the length of the lines is shorter, which of course allows for less loss. Wire has a resistivity of ohms per mile. So of course, the longer the line at the same ohms per mile, the more loss you have. And the only real way to combat that is to use bigger wire. And then you'd have, so you could combat that by using bigger wire to get lower resistivity. But whether it's worth the extra cost or not is not something that I've ever that I've considered. Like I said, they do this to try to keep an operational system that customers can afford to have.
Right. Yeah, no, I appreciate that there's a trade-off between, the quality or reliability and the cost to it. I guess what I was trying to compare is just, other systems that might have similar lines, just some that come to mind are maybe like Idaho Power or Northwestern in Montana, some of those areas that might have longer lines like perhaps SPS does. If it's not a good comparison with EP and PNM because of the terrain, that certainly makes sense to me. I'm just trying to make sure that even given the lower cost as compared to other systems that may be similar, that the performance, is what we would expect, recognizing that if you want better reliability, it's going to cost more money. So I guess I'm wondering if it's, if it would be okay to look at some of those other utilities like Idaho Power, Northwestern, to see what kind of performance they have in terms of losses, and others that you might think are similar if EP and PNM are not.
Commissioner, are you suggesting that staff do that comparison for this case or as a future endeavor?
Well, it sort of started from the concern that was expressed in the initial testimony, and there seemed to be a request or, for a recommendation for a requirement to have SPS look into this, and then the stipulation does not address it. And I think, I'm not necessarily asking for a whole lot of work. Maybe there's an Idaho Power rate case, and that sort of, it just explains what the losses are for them, and just I think it would be helpful for this case. And again, don't think we need to spend a whole lot of time on it, but do think that we need to make sure that that we have a good comparison to evaluate the loss performance here.
Well, I have believed since my testimony that SPS should be required to do a study and file a report along these same lines.
Mm-hmm.
Whether, I'm not sure that that would be appropriate in this case, given the amount of time it could take. I don't know how long something like that would take. But I believe that that would be something good to have them do.
So,
Sure.
Yeah, go ahead.
Commissioner Aguilar, would you like me to issue a bench request that requires staff to file something?
It doesn't necessarily need to be staff. I think if maybe SPS has this information, they might be in a better position to identify which systems are accurate and would be a reasonable comparison.
Very well, sir. Ms. Hardy, Mr. Bagacco, please consider this a bench request from the commission that some type of identification and comparison with similarly situated utilities that support or are similar to SPS's claim in the rebuttal testimony of Mr. Ripperger as the justification for the same or similar type of transmission properties that SPS has.
Understood.
Will that get to what you're looking for, Commissioner Aguilera?
That would, and again, hopefully I'm not asking people to spend too much time on this. I'd be happy with like a brief table that compares other utilities, even if it's all of utilities in the West, for example. I don't think it would be too difficult to find the loss rates.
Okay, Madam Hearing Examiner.
Sorry, Mr. Bagacco, go ahead.
I was just going to clarify. So we want a table that compares the ultimate numbers from comparable utilities who have rural operations similar to SPS, correct?
Yes.
Thank you, Commissioner. And for clarity's purpose and my sanity, this would be bench request number 13 that we would be responding to, correct, Madam Hearing Examiner?
$14.
14. Thank you very much for that. We are happy to do it, and we'll work with SPS to that end.
Well,
Your Honor.
For our purposes, let's consider it 14. I think I've made a mistake and I've combined my exhibit numbers with my bench request numbers. And I don't want to be more confusing than I already am. So 14. Ms. Hardy?
Your Honor, I think this information is going to take quite a bit of time for SPS to track down. I think it requires likely digging through rate case filings in many other states for many other utilities, even if we're only looking for a few. So this would be something I would need to get a time frame from SPS, but it's not something we could turn around within a couple of days, I don't believe. It's a very time consuming, I think, process to put this information together.
See what you can find out, Miss Hardy, over lunch, and let me know when we come back.
Okay.
Okay.
I will do that. Thank you.
Commissioner? Do you have other questions for Mr. Sidler?
No, those were my questions, and thank you for entertaining my request again, and not intending to, have people spend too much time on this. Yeah, thank you.
Thank you, Commissioner. Any other questions? Mr. Bagatko, any redirect?
Madam Hearing Examiner, I think I can dispense with redirect in this instance. Thank you for asking.
Very well. Any questions, Ms. Lynch?
Yes, I have a few follow-up questions related to yours.
Very well.
Thank you. Hello, Mr. Sidler. My name's Carol Lynch, and I'm the attorney for Coalition for Clean Affordable Energy.
Hello.
Hey, earlier in the cross that the hearing examiner conducted of you, she asked you about section 4 of the stipulation about Nichols units 1 and 2. Do you remember those questions?
Yes, I do.
Okay. Do you remember answering that the units, the Nichols units, are being extended to account for fluctuations in renewable energy on the SPS system?
I believe in the filing of the case that they specified that they wanted to extend to the Nichols units to be used for load following for renewable energy.
Would you accept it as true that the reasons SPS proposed for extending the lives of Nichols is to meet expected load growth and capacity need and SPP requirements?
That could be a part of it.
Okay. Are you at all aware whether SPS requested bids for new renewable energy or storage as alternatives to meet the needs they hope to meet with increased utilization of Tolk or Nichols?
I'm not aware of those issues.
Thank you. Did any of SPS's proposed scenarios in its application include renewable energy or storage?
Proposed scenarios, and how do you mean?
In the initial application that SPS submitted before the commission?
I don't recall anything along those lines.
Does the stipulation include additional renewable energy or storage, particularly to meet the demands for Nichols units 1 and 2?
The only part of the stipulation that I would say would be close to that would be part 16 that provides for the timing of replacement resources to address the retirement of Tolk and other SPS needs.
Related to the IRP.
The IRP process.
Thank you. And my last question is, would it be reasonable or in the public interest for a company not to evaluate scenarios that include renewable energy or storage to bring forward to the commission for consideration?
I'm not aware that it would. I'm not aware that it would be proper to not consider them.
So in your opinion, it is reasonable that the only scenarios presented for the commission did not include renewable energy or storage?
Well, in this case, there's the only issue, the only availability they had was nickels. I mean, they do say in the stipulation that their IRP is going to address replacement resources for chalk and to meet other plans. So I would believe that the IRP will address those issues.
But they were not analyzed or brought forward here, correct? There were only 2 scenarios analyzed for the commission to compare.
I'm not sure what they analyzed and what they didn't.
Were you listening to the testimony of Elsie? Where
Bits and
he
pieces.
confirmed that the company only
Can't
analyzed.
testify. 'Cause you have to,
Thank you.
I've only heard bits and pieces, as I do have other testimonies and other responsibilities in addition to this case.
Thank you, Mr. Sidler. I appreciate your responses.
thank you, Ms. Lynch. Anything further? Any questions from any other party? Hearing none. Mr. Sidler, you are excused, sir.
Thank you.
Thank you. Well, given that it's almost the luncheon hour, I believe it might be appropriate to take our lunch recess until 1 o'clock. We'll come back, and I believe you have one more witness. Mr. Bagatko, you have Mr. Tupler.
That is correct. Our last witness is Mr. Tupler.
And then we'll hear from CCAE witness, Mr. Long. Very well. Thank you all very much. Remember, we're live streaming, and we are recessed until 1.
Thank you.
Mr. Tepler, what's your area of testimony?
This will be return on equity.
Thank you very much.
Yes, sir.
Just want to know what to expect. I'm ready for my beating, Mr. Tepler.
I'll speak steady and enunciate.
You're the man.
Mr. Lee, are we ready?
Yes, ma'am.
All right, sir. Good afternoon. We are back from our luncheon recess. And I believe that staff has another witness, Mr. Bagacco.
That is correct, Madam Hearing Examiner. Staff's final witness in this case is Mark Tupler.
I see Mr. Tupler. Good afternoon, Mr. Tupler.
Good afternoon, Madam Hearing Examiner.
Mr. Lee, would you please swear the witness?
Yes, Your Honor. Mr. Tepler, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you,
Thank you,
sir.
Mr. Lee. Mr. Bagacco?
Madam Hearing Examiner, thank you. Mr. Tupler, good afternoon.
Hi there.
We've got a couple items that consist of your pre-filed testimony that I'd like to try to move into evidence. So if you'll bear with me, I'll start with what's been provisionally marked as Staff Exhibit 8, which, if you would confirm to me, consists of your prepared direct testimony filed in this case on April 21st, 2023. Is that correct?
Yes, sir.
And I perceive that you have a copy of that in front of you, correct?
I do.
And that is what, to your knowledge, was uploaded and downloadable from Dropbox in this case. Does that meet with your understanding?
Yes, sir.
Mr. Tupler, would you please take a moment and just flip through Staff Exhibit 8 to make sure that it is a complete and accurate rendition of what you caused to be filed in this case back on April 21st?
Okay, it does look to be inclusive.
Thank you for that. And your testimony includes 3 exhibits labeled Exhibit MAT1, MAT2, and MAT3, correct?
Yes, sir.
So this testimony and the exhibits attached thereto, all of that was prepared by you or under your direct supervision, correct?
Yes, that's correct.
And I also understand, Mr. Tupler, as we sit here today in cyberspace or wherever you may be, that you do not have any corrections to make to that pre-filed testimony. Am I correct?
There are none.
And then finally, Mr. Tupler, if you were asked the same questions today at this public hearing as we see posed there in that pre-filed direct testimony, would your answers to those questions still be the same, or would you have cause to change them?
They would be the same.
Thank you for that. And with that, Madam Hearing Examiner, I would then move for the admission of the prepared direct testimony of Mark Tupler, provisionally marked as Staff Exhibit 8, into the evidentiary record for this proceeding.
Any objection to what's been identified as Staff Exhibit 8? Mr. Tupler's pre-filed testimony as verified by him here today and as placed in the Dropbox. Hearing no objection, Staff Exhibit 8 is admitted.
Thank you, Madam Hearing Examiner. Now, Mr. Tupler, if you would direct your attention to your testimony in support of the contested comprehensive stipulation. I trust and hope that you have an electronic copy of that in front of you. Am I correct?
It is loading and it is here.
Thank you. And you'll note that it's been provisionally marked down in the lower right-hand corner of the first page as Staff Exhibit 9. Is that what you see before you?
Yes, sir.
Now, similar to what we just did, would you please take a moment and flip through that testimony in support of the contested comprehensive stipulation to make sure that it is a complete and accurate rendition of what you caused to be filed in this case on May 26th.
Okay. It looks to be inclusive, yes.
Thank you for that, Mr. Tupler. And this time around, your testimony in support of the stipulation does not have any exhibits. Is that correct?
That is correct.
And similar to what we discussed before, this testimony, I understand, was prepared by you or under your direct supervision. Is that correct?
Yes, sir.
And you do not have corrections to make to this testimony in support of the stipulation. Is that true?
I have no corrections.
Thank you for that, Mr. Tupler. And then finally, if you were asked the same questions today at this public hearing, as we see posed in your testimony in support of the contested comprehensive stipulation, would your answers to those questions be the same, or would you have cause now to change any of them?
They would be the same.
Thank you very much for that, Mr. Tupler. And with that, Madam Hearing Examiner, I would move for the admission of Staff Exhibit 9 into the evidentiary record for this case, please.
Thank you, Mr. Bagacco. Any objection to what's been identified as Staff Exhibit 9, Mr. Tupler's testimony filed in support of the contested stipulation as verified by him here today and as placed in the Dropbox. Hearing no objection, Staff Exhibit 9 is admitted.
Thank you. And I understand that Mr. Tupler has not been identified as a subject of any cross-examination, but that Madam Hearing Examiner and one or more commissioners likely have questions for him. So I respectfully tender Mr. Tupler for such examination, please.
Thank you, Mr. Bagacco. Good afternoon, Mr. Tupler.
Good afternoon.
In addition to your testimony in support of the stipulation, is there any request that you made in addition to the stipulation that you would like the commission to consider?
Well, in terms of the stipulation, I focused strictly, it's outlined in the stipulation, I focused strictly on the return on equity and the capital structure, if I'm not mistaken. Outside of that, my other staff colleagues focused on their areas of responsibility. So I believe my concerns and issues are addressed in my my supplemental testimony in support of the stipulation.
Thank you, sir.
Yes, ma'am.
Commissioner Ellison, I believe that you have questions for Mr. Tupler.
Yes, I do.
Go ahead,
Good
sir.
afternoon, Mr. Tupler.
Hello, good afternoon, Commissioner Ellison.
I had just a few questions. What was your recommended capital structure for SPS?
So in my direct testimony, I supported the status quo, which I believe was 54.7. I take the approach that it seems to work for the company. So it didn't require any change that I saw that was outside of the parameters that I would typically establish for a traditional capital structure.
Okay, and I see that you did state that increasing the level of debt may provide cost savings to the ratepayer. Is that correct?
Yes, sir.
So I'm wondering if you could explain why you didn't recommend an adjustment to the capital structure, given that.
Yes, sir. Sure. First and foremost, I would tell you again, I support the status quo because the existing capital structure does seem to fit the company well enough. In a lower interest rate environment as well, the addition of additional debt, if I can say it that way, lower cost debt is a cost savings to ratepayers. I think originally when this case was filed and the testimony was drawn, the interest rate environment did shift some. As we all know here, the Federal Reserve Board has increased interest rates, I believe it to be 10 times, maybe something like that over the last year. It's extraordinary in history from my perspective, but it is an indication that debt is increasing in price. Thusly, my idea that additional low-cost debt in a low interest rate environment could be wise to the capital structure, could be tempered a bit. It's hard to predict what the Federal Reserve Board is going to do, but overall, I would still say that we are in the midst of a low interest rate environment historically. However, from a banker perspective, I am certain that all of the utilities companies, banks like additional equity as opposed to debt. As a former banker, I can definitely say that bankers like to see more equity in a company than over leverage. That is a fine line. I know that the basic regulatory construct is 50-50. Anything within about 5 percentage points of that, in my opinion, is fully acceptable.
Mr. Chris had a table that he took from a S&P database with the average debt or equity to debt ratios of utilities that had received rate case decisions in various years. And if you look at, I'm not sure if you had a chance to review his testimony. If you look at the table for 2022, it seems that SPS is asking for about 4 percentage points higher than the average utilities percentage of equity that was authorized in that year. To you, does that indicate that, you know, there's room for adjusting SPS's equity ratio downward to sort of better align with the median?
Well, I don't know if I understand the circumstances behind what the other utilities in that study group are comprised of. They could be taking advantage of the low interest rate environment. What troubles me with moving a capital structure from an existing capital structure to something with less equity is the impact that it would have on the company's credit rating. If I'm not mistaken, the average utility company in that study would most likely have a higher credit rating than SPS. And given the rather tough distinction between investment grade, which is where they are a couple clicks away from junk bond status, or non-investment grade status, I guess is what it's more appropriately called, but it's known in the industry as junk bond status, would be catastrophic from my position. As such, I couldn't necessarily determine, based on that study group, why SPS is so far out of line from that average. It would require some understanding of the capital structure and the credit ratings of the other companies.
You know, I think, you know, that data is there in, you know, Mr. Chris's testimony. It outlines the specific utility operating companies and the equity percentage that was authorized. And I think it wouldn't be that hard to look up the you know, the rating of those particular companies. You know, just speculating, I would think that almost all of them are going to be investment grade rating, being, you know, regulated utilities. So I guess, you know, it puzzles me why SPS feels that any drop in equity would endanger their credit rating, whereas the average equity percentage is about 4 points lower of, you know, peer companies that also have investment grade ratings. Thank you, hearing examiner Hurst. So isn't there the chance that, you know, this is sort of a red herring that's being thrown out by SPS in order to get us to approve their current equity percentage?
Yes, sir. I get the gist of this question. Because it's a status quo equity percentage, I don't have concern with it. If it was a request for more equity, I would have dug into it a little further. Keep in mind also that this list of companies here far exceeds the peer group that I established for my analysis in my testimony, and would be skewed sizably because of its number. There are a number of companies here that are not peers. If you'll notice in my testimony, however, I did an analysis of the same data to come up with a much more relevant, comparable, apples to apples peer group that I am much more comfortable with.
Was your peer group at the holding company level?
I believe these are operating companies.
In your peer group?
Yes, sir.
Okay, just because that was a distinction that's come up, that Mr. Diascendis's proxy group appeared to be all holding companies. And when we're looking at the equity ratio, wouldn't it seem to be more appropriate to look at other operating companies for a comparison?
That would describe an apples to apples comparison, which I think is important in this type of analysis, because there are such large peer groups, what are considered peer groups, in some of the other testimony that I could not support.
Okay, I wanted to ask a little about your CAPM analysis. You determined an equity risk premium of 7.7%. Is that correct?
In my CAPM, I guess, let me do the math here.
So I'm just looking at your testimony, page 36 of the PDF, 35 of your document. You've got that it indicates a market risk premium of 7.73% over the last 65 years of data.
Okay, yes.
Yes. Thank you, Hearing Examiner Hurst, for putting that up on the screen at the top of the page here. So would you agree that the equity risk premium is a forward-looking estimate, that, you know, we're really trying to estimate what you know, the returns on the market will be, you know, indefinitely when we estimate that equity risk premium?
Well, I didn't do an equity risk premium analysis in this particular case. I focused instead on the DCF, which is the Historic Commission's precedent.
Well, you do have the market risk premium of 7.7%. So that is, you know, in effect, an equity risk premium, isn't it, that you calculated?
I would say that that is more of an observation of the equity risk premium historically, which then could be used in conjunction with the risk-free rate to come up with a maybe an expected return.
Right. So I guess, you know, where I'm going with this is that, you know, I'm just wondering how relevant it is to look at past returns over a 65-year period to estimate what the market risk premium or equity risk premium is going forward.
Yes, sir. I would agree with that. And I believe that is the basis for why the equity risk premium method is not necessarily utilized in rate cases, is because of that defect.
You know, I'm wondering, you know, some of the other witnesses, such as Professor Woolridge, looked at, you know, a variety of studies, you know, sort of academic studies and, you know, large companies that publish their estimates of equity risk premium, as opposed to, you know, doing your own equity risk premium study. What are your thoughts about that? Does it make more sense to look at, you know, published studies, or to do your own study?
Sure. From my experience, third-party providers of data can and will influence the numbers based on proprietary methodologies, if you will. They will take a number that is a raw number that is reported and do something to it to standardize it, maybe. I think it's wise to look at third-party numbers and data, as long as you understand the methodology on how they got there. Because if that methodology makes sense to you and is in line with, you know, your experience, your observed experience, it could work. However, in my history in the investment markets, you got to be careful with the data so that you are not taking the data at face value because of their tendency to skew it in one favor or another. So I think it's important to use them almost complementary take third-party data, understand its basis, understand its skew. A skew is not necessarily good or bad. It's a professional judgment by the company, and then apply your own observations or analysis to it to come up with what I would call, a sharper pencil.
Okay, but certainly there's more than, sort of company estimates like Kroll or KPMG that are out there. I mean, there are academic studies that have been peer reviewed where, there should be visibility into how they came up with these estimates. So I guess I'm wondering, why reinvent the wheel when there are published studies out there on the equity risk premium that we could draw on?
Yes, sir. I would tell you my observation of that, though, is that in my investment career, I saw upwards of 80% of analyst studies miss the mark over and over again, which is why I took an approach that was maybe trust but verify, analyze, understand, and form an opinion.
Well,
Because
I certainly agree that, if you're talking about Wall Street analysts and, sort of their growth estimates, that, there seems to be some bias baked in there. But, I'm really talking about sort of a neutral third-party academic assessment of the equity risk premium. I think those are sort of two different things.
Well, so you mentioned that it is an academic study. There might be a disconnect between the academic study results and what the open market produces, is my opinion here. It also serves as the basis for why the DCF is the chosen or the preferred methodology here, because it doesn't take into an account, any of the data that can otherwise be skewed.
Right. Mr. Depreciation argued that the DCF or dividend discount model method should be taken with a grain of salt because it has consistently given results lower than approved ROEs. What is your view of that?
Bless you.
I think the only variable there that could lead to that observation is the growth rate factors that are used in that type of calculation. Otherwise, you're dealing with market-driven numbers of price and dividend. They are what they are, and the market proves them to be accurate. I can't say that I've noticed or had any type of observable difference between approved ROEs and the DCF ROEs, but that gap there is maybe defined as the gap that the commissions behind those approvals, it's their discretion at that point.
Right, there could be other factors behind why the commission might approve something higher than a DCF would suggest. And as you say, well, it seems like, there's still some leeway into how you estimate beta and how you estimate growth rates. So wouldn't you say that even in the implementation of this DCF model, that different practitioners could come up with different numbers?
Well, using the DCF, the numbers should be closer than any other method used from my position.
I guess another issue, Mr. Depreciation argued that there is a New Mexico DCF calculation. Are you familiar with that?
I can't say I've heard that term before, but I'm curious.
Right. That was new to me too. So I think because in the past, in the previous litigated SPS case 17286, am I correct on that? Hearing examiner Hurst, I don't quite remember the number, but the last litigated SPS case, given that SPS was on credit watch for a downgrade, the commission agreed with a specific flavor of the DCF calculation that did an average between the median and the median high results for the peer group. Now, that in your view, does that box us in to using that particular flavor in the future, or is that a New Mexico DCF calculation as he has termed it?
I think you may have identified what the New Mexico DCF flavor is. I was unaware of that, but I've got to imagine that they're reasonably close. Again, utilizing an apples to apples peer group, the numbers, mean and median, will be close.
Well, yeah, I guess I was referring to something a little different, that the median and then the median high, it's a specific, it's a kind of specific flavor of it. And, it's certainly not something that you used in your analysis. So I was just questioning around whether it's fair to label this particular flavor of the calculation a New Mexico DCF or not.
Right. It's an interesting observation. So median high would put the number above, or put it a little higher than the average, if I can call it that, which I'm presuming was intended to offset any negative credit.
Yes, it was a adjustment that made sense to the commission at the time, given the negative credit watch. But in my view, does not define what the commission has to do in the future. Anyway, that's in that. You can see in Mr. Diascendis's analysis, exactly the calculation that he does, that he's calling that. I think that's all the questions I have, Mr. Tupler. I appreciate your work on the project and appreciate your answering my questions.
Yes, sir. Thank you.
I'm sorry, Commissioner, I don't have that reference. I'm
sorry, which reference? Hearing examiner?
The case reference that you were looking for.
That's fine. It's just the last litigated SPS case that I was referring to.
If I may, are you talking about 17-00255-UT?
That sounds right.
And I know I know that on page 52 of SPS Exhibit 16, which is Mr. D'Ascendis' direct testimony, he refers to 17-00255 as being SPS's most recently
That's
litigated.
correct. That's, I'm
case.
sure that's right. That's what I was referring to.
All right, sir. Thank you. Mr. Tupler, I think that one of the issues that has been focused with regard to the ROE and the common equity percentage, there's been a lot of focus drawn to what might happen out in the credit rating world about these numbers. Are you familiar with that testimony?
Yes, ma'am.
Do you, based on your knowledge and experience, place as much emphasis or importance on the commission determination of those numbers as does SPS?
Help me understand that question, Madam Hearing Examiner. I don't know if I caught it all. Am I familiar with?
Well, in analyzing ROE and common equity, there are different methodologies and different information that goes into that. But the importance, in addition to the importance of actually how much the company might have an opportunity to earn, there are testimonies in the record that also talk about how the commission determination of a company's ROE and common equity, how those might potentially affect a credit rating agency's opinion. Do you believe that to be true?
Yes, ma'am.
And since you believe that to be true, SPS witness, especially SPS witness Martin, and to a lesser degree, SPS witness Trammell, seem to indicate that depending on what the commission decides, it could have a negative effect on these credit rating agencies' opinion of SPS. Correct?
Yes, ma'am.
Do you also believe that?
I do.
Why?
Well, first and foremost, I would say that the utility industry is unique in these credit rating agencies because most credit rating agencies, for the average company that they would analyze, would focus first and foremost, up to 60% of their grade would be based on the cash flow of the company. In a regulated utility environment, it's a little different because the cash flow is regulated and approved. So there's not as much risk in a deficient cash flow because it's ordered by the commissions. What these credit rating agencies look at next in line, because there's maybe 5 or 6 different risk categories, each having a different weight, they will look at in determining their overall grade. With regulated utility companies, what the credit agencies want to see is supportive regulatory environments. So that includes predictability, stability, and timeliness, because that you take away the cash flow risk and the next risk in line becomes the regulatory risk. From there, they take, they take a look at ratio analysis in the financial position of the company. And I just haven't looked at one in a few months now, as this testimony has been, or this case has been going on, but they do list out most of the most of the credit reporting agencies will list out the 5 or 6 different risk categories that they will look at. In a regulated utility environment, regulatory risk is their largest weighted component.
Well, what seems to be unclear to me is if this is the third rate case since SPS's downgrade, and if both of the prior rate cases were stipulated and agreed to by SPS, and ultimately the commission issued favorable orders in those 2 particular cases, and I'm failed to understand why number one, there hasn't been an upgrade. If what the commission has done with regard to SPS in the last 2 rate cases is not considered predictable and stable and favorable, then what is it?
Yes, ma'am, I can address that if that's your question.
It is.
Okay, so if I'm not mistaken, at this point, the company is on a stable watch, which means that the credit agencies are waiting for something to happen that would either improve their credit rating or, of course, decline or detract from the current credit rating. These credit reporting agencies have teams of people that will look at these cases. They are probably waiting for something outside of a settlement to make determination of what their risk levels are going to be interpreted as. In the meantime, what keeps the company on this, from my perspective, what keeps the company on a stable rating is the financial measurements and financial ratios that have been established with the operations and with the settlement, or the stipulation, maybe more appropriately. They are utilizing very standardized industry metrics. And if there's not a lot of variability there, the credit agency will keep a stable outlook, is the term, before they make any changes, upgrades, or downgrades. So it's credit metrics that they're relying on at this point to keep it stable. And I believe that settlements will probably, or stipulations will probably never upgrade or downgrade the credit rating unless there's something extraordinary that happens to improve or to the detriment of the financial ratios that are measured.
So if I understand your explanation, if in this case, the commission were to reject stipulation give SPS the $75 million that it initially requested, it probably would be upgraded.
Well, I think there'd have to be other factors involved besides just the 75 million. But
At the rate of return that they ask for, at the capital structure that they ask for.
I would consider that to be very credit positive, yes.
Okay, so we've got to either give them what they ask for or give them more than what they ask for, and then they're going to be upgraded.
I think that might be beyond a fair and reasonable decision, though, because there's a range that would lead to an upgrade, as an example.
A range of what?
Well, if the commission was to award maybe 75% of what was requested, I would still consider that to be credit supportive. If it was 50% of what was requested, I think that's maybe the gray area where agencies, the credit reporting agencies, would question the basis to what's happening. Then they would make their decision on stability or upgrade or downgrade based on those numbers.
Did you have a chance to look at what got filed this morning? In this case?
I'm sorry. I did get a chance. I saw it come through. If you remember, I was on deck before lunch, so I was trying to focus on getting here. I didn't get a chance to review it entirely, but I did take a quick glance at it to see if there was anything that stood out to me. There was nothing that stood out to me.
Well, for the record, SPS filed a supplemental response to hearing bench request 1-8. And so this is a supplemental response to the bench request issued to Ms. Crane that wanted to know that SPS collaborated with, that wanted to know the impact of using a 9% ROE.
Yes, ma'am.
Holding everything else equal. And I believe the answer had been, if you leave everything else equal, there's approximately an $8 million reduction.
Yes, ma'am.
You recall that?
I do.
And from the 33, and basically at the end of this response, there's a claim made by sponsors Martin and Trammell that a rejection of the stipulation in whole and part will be viewed as a non-credit supportive by investors and rating agencies and could impact the financial and business risk assessment of SPS, which in turn would impact SPS's cost of capital as well as its access to capital. The impacts would harm SPS, retail customers, and impair SPS's ability to meet renewable energy requirements and goals. Do you agree with that, Mr. Tupler?
I think the word that you used in that description there was would. I would say that it would be accurate if it was could impact the company's credit rating.
So you mean by that potentially that it might or might not?
Well, it would simply lead to a litigated case, if I'm not mistaken, which the credit agencies would hold tight until that is resolved. But if the stipulation dissolves, I couldn't imagine the credit agencies taking that as a positive outcome.
So in other words, in rating agency land, the commission doesn't get any credit for approving a stipulation as far as points toward predictability or stability. But if the commission doesn't approve the stipulation, then the commission, again, in rating agency land, could potentially have points taken away from the stability and predictability and whether or not this is a favorable climate. Is that right?
Good question. Let me think about that for a second here. So there's two comments that I would make to that. First and foremost, the commission, like you commented, wouldn't get any credit for a supportive stipulation. But I think that because of the past stipulations that have occurred and approved, this would be another step in the right direction for giving the commission the credit that is due. If it's not supported, the financial ratios become a bigger variability here, or a bigger variable here, because that's what the credit agencies would be looking at in absence of anything positive or supportive, because the regulatory risk is such a large weight in their calculations. So to kind of put a bow on that, if the commission supported it, it would be a giant step together with the past support in giving the commission the credit it's deserved.
Now, does that contradict your prior testimony that said that the approval of the stipulations pretty much had it in a holding pattern until something happened positive or negative?
I could see how that would be the case, but note that I mentioned that it is in this decision would be in conjunction with prior approvals of stipulations that do show, from my perspective, a supportive regulatory environment. Once or twice, I would say, is, maybe more of a happenstance. 3 stipulations in a row is a pattern.
Based on what?
Just analysis skills that I've developed over time. One thing can happen. A second time is maybe luck. A third time does designate a pattern from my chair.
Okay, fair enough. That's, I appreciate the clarification, Mr. Tupler.
Yes, ma'am.
Mr. Brigacco, any redirect for Mr. Tupler?
Just a little bit, if you please.
Sure.
Mr. Tupler, during your testimony, we just went through, you used the number of times apples to apples peer group. Do you recall that?
Yes, sir.
What do you envision or mean when you use that phrase in the context of what you do here as an ROE cost of capital witness?
Yes, sure. It's important in establishing a reasonable peer group to include actual peers. From my experience as an investment and business banker, it's almost impossible to compare a $3 billion company with a $30 billion company. Or if I take a look at the Hope and Bluefield U.S. Supreme Court directive, you have to have regional peers. A company on the coast is going to be different than a company in the mountains or in the middle of the plains, or whatever distinction you can make. I believe it's Bluefield that says that location and region is the important part of it. As I developed my peer group, I took the same data set that every other witness utilizes from Value Line, I believe is where the majority take their information. And I narrowed it down to actual apples to apples peers.
So in addition to region and location, you're also considering similar financial metrics, if I understand you correctly. Is that right?
Well, I used I didn't use the metrics as much as I used the size. Again, a $30 billion company operates differently than a $3 billion company. They're not apples.
Okay. Well, thank you for that clarification. And that's all I have on redirect, Madam Hearing Examiner. Thank you for your indulgence.
Thank you. Any questions for Mr. Tupler based on the commissioner's questions, my questions, and any redirect? Seeing no other questions, thank you, Mr. Tupler. You're excused, sir.
Thank you, Madam Hearing Examiner.
Thank you. Mr. Bagatko, anything further from staff?
Nothing further from staff. Thank you, Madam Hearing Examiner.
Well, I believe then with the completion of staff's presentation, we can go to our remaining witness for today. And I believe, well, Ms. Lynch, would you like to go ahead while we're going to get Mr. Long? And I don't believe that we've stipulated in the testimony of Mr. Batts.
I think that'd be a good idea.
Let me check my. No, I don't see that on my exhibit list. So go ahead.
CCAE submits Exhibit 3, the direct testimony of Brendan Batts.
And the version. Now the copy I have has CCAE Exhibit 4 on it. Is that correct, or are you correct in calling this CCAE Exhibit 3?
I'm sorry if I mislabeled that. Let me take a look. I have it labeled as CCAE Exhibit 3.
Okay. And CCAE Exhibit 3 is the version of Mr. Batts' testimony that was placed into the Dropbox.
Correct.
And the version of Mr. Batts' testimony, CCAE Exhibit 3, meets all of the requirements for waiver of appearance of the witness and submission of stipulated testimony. Ms. Lynch?
Correct.
Any objection to what's been identified as CCAE Exhibit 3, Mr. Batts' pre-filed testimony as placed into the Dropbox and pursuant to the assertion of meeting the requirements for waiver and of appearance and stipulating into the record? Hearing no objection, SPS Exhibit 3 is admitted. Ms. Lynch?
Thank you. I'd like to offer up our next witness to be sworn in.
Very well. Hello there, Mr. Long. Welcome.
Hello, Madam Hearing Examiner.
Mr. Lee, could you please swear in Mr. Long?
Mr. Long, would you raise your right hand? You solemnly swear the testimony you're about to give in the matter of nothing to be the truth, the whole truth, nothing but the truth.
I do.
Thank you, sir.
Thank you, Mr. Lee. Go ahead, Ms. Lynch.
Mr. Long, could you please state your full name for the record?
Yes, my complete name is Noah Baker Long.
And in what capacity are you employed and for whom are you employed?
I am employed as the Western Director for Climate and Clean Energy for the Natural Resources Defense Council.
Do you have before you a document labeled direct testimony of Noah Long?
I do.
And can you identify it as the document we submitted to Dropbox in this case?
I can. I believe it is CCAE Exhibit 2.
Correct. And was this document prepared by you or under your direction?
Yes.
Any attachments in the testimony were prepared by you or prepared under your direction, correct?
I approved its attachment. I didn't prepare it per se. It's from a separate case at the PRC.
Okay. And if the questions posed in that testimony were posed today, would your answers be the same?
Yes.
Okay. With that, I move for the admission of the direct testimony of Noah Long, CCAE Exhibit 2.
Mr. Long, if you were asked these questions today, would your answers be the same?
Yes, ma'am.
Any objection to what's been identified as SPS Exhibit 2, Mr. Long's direct testimony filed in this case as verified by him here today and as represented to be placed into the Dropbox? Hearing no objection, as CCAE Exhibit 2 is admitted. Ms. Lynch?
Thank you. Do you have before you a document labeled CCAE testimony in opposition to stipulation?
I do.
Can you identify it as the same document we submitted in testimony in this matter when we submitted it to Dropbox?
Yes, and I believe this is CCAE Exhibit 1.
Thank you. Was this document prepared by you or under your direction?
Yes.
If you were asked the same questions today, would your answers be the same?
Yes.
And with that, I move for the admission of CCAE Exhibit 1, the testimony in opposition.
Any objection to what's been identified as CCAE Exhibit 1, Mr. Long's testimony in opposition to the stipulation as verified by him here today and as placed into the Dropbox? Hearing no objection, CCAE Exhibit 1 is admitted. Ms. Lynch?
Thank you. Mr. Long, do you have before you a document labeled CCAE Exhibit 4, our statement in opposition?
Yes.
Okay. Can you identify it as the same document we submitted to Dropbox in this matter?
Yes. Give me a moment here. I apologize. I'm just juggling files here. Yes, and I believe this is CCAE Exhibit 4.
Correct. And was this document prepared by you or under your direction?
In part, this is a statement filed under your name. I did participate in looking at it and writing it.
Okay. And if the statements made in that exhibit, are those statements the same today if you were asked the same questions?
Well, I apologize. These aren't formed as questions to me. These are the statement by CCAE. So I didn't answer direct questions in this document.
Would those statements that were made be the same?
I believe so.
Thank you. And with that, I move for the admission of CCAE Exhibit 4.
I'll just note, I mean, as a pleading to the case, I can take administrative notice of this particular exhibit. However, since the stipulation was admitted as an exhibit, unless there's opposition to the pleading, opposition to stipulation filed by CCAE, I will admit it. Hearing no objection, SPS Exhibit 4 is admitted. Ms. Lynch?
Thank you. I pass the witness.
Thank you. According to my recollection of the pre-hearing memo, there was time reserved for cross-examination for Mr. Long, and I believe SPS has requested 45 minutes for cross-examination for Mr. Long. I believe the only other party that requested cross-examination for Mr. Long was staff, and that was 20 minutes. Did any other party, am I forgetting any other party who
Madam
reserved
Hearing
time?
Examiner,
Ms.
this is
Drake.
Joan Drake for LES. We had actually preemptively reserved 10 minutes. I don't think we will believe that or need that. But I'll wait to give you a final answer on that until we hear the cross-exam by others, if that's okay with you.
Very well. Thanks for reminding me.
That's fine. Thank you.
Thank you.
Madam Hearing Examiner, this is Major Buchanan. FEA had also reserved 10 minutes. However, I do not believe we will be using that time.
Okay. Thank you, Major. Any other party?
Madam Hearing Examiner, this is Joshua Smith on behalf of Sierra Club. We had likewise reserved a few minutes. but we'll likely not have any questions for Mr. Long. But I would reserve an opportunity in response to any questions you may have or the other commissioners may have to ask him any follow-up, please.
Very well. It's been a while since there's been any cross, so I appreciate the parties stepping up and letting me go, or letting me let me go, letting me know what time had been reserved. So we'll start out then with Ms. Hardy and SPS, followed by staff. Well, no, I guess I better stick with the order. I'll just start with SPS and then I'll follow the presentation order on that. So, Ms. Hardy, you have 45 minutes.
Thank you, Madam Examiner. Ms. Kane will be conducting the cross-examination for SPS.
Very well. Hello there, Ms. Kane, over there in the corner. You have 45 minutes.
Good afternoon. Madam Hearing Examiner, I did want to note, I think when you were admitting that last exhibit, you might have identified it as SPS Exhibit 4, or just for the record, I believe it's CCAE Exhibit 4. I just wanted to note that before we move on.
Okay. Mr. Lee, if I said SPS, I meant CCAE. All right, sir?
As luck would have it, I've already fixed it.
Oh, excellent.
Working
Thank you.
synergistically.
Excellent. I think, I believe that you had 79 exhibits, if I'm not mistaken.
That sounds about right. That sounds about right. We passed it for a while ago. That is correct.
Yeah. So the mouth is used to saying SPS. So I thank you for that. And Ms. Kane, I will start your timer now.
Thank you, Madam Hearing Examiner.
Thank you.
Good afternoon, Mr. Long.
Good afternoon, Ms. Kane.
Mr. Long, I want to start by asking you to just clarify for the record kind of the scope of what CCAE is contesting with respect to the stipulation. And is it correct that you are not contesting the ROE that is included in the stipulation?
That's correct.
And is it correct that you're not contesting the stated common equity ratio?
Yeah, that's correct.
And you're not contesting the rate design portion of the stipulation, correct?
That's correct. Not to my knowledge. I wasn't the only witness for CCAE, but certainly not addressed in my testimony.
Okay. Now, to turn to your testimony, one aspect of the stipulation that you've raised concerns with is in regards to the operation of the TOLC units, correct?
No, I wouldn't say that that's quite correct. I'd say that the concern that I've raised specifically is related to the cost recovery for changes in utilization for TOLC, which is similar, but a little bit different.
Okay. And would it be correct, and feel free to reframe this if you need to, that your position is that SPS should not receive recovery for costs for operating the TOLC plant above 2,400 gigawatt hours a year?
That's almost correct. I mean, I'll just restate that quite a little bit if it's okay. My view is that SPS has used this rate case to receive cost recovery for effectively new resource decisions in both the case of TOLC and Nichols, and that those decisions have not been adequately analyzed and therefore are not neither prudent nor in the public interest, nor reasonable, I should say, or nor in the public interest. And so at this juncture, I would recommend disallowing the costs that are included in the settlement with regard to those, as well as disallowing new and potentially unlimited NOx costs associated with the changes in resources that.
Okay, let's go back to the Tolk unit. You
Sure.
have an issue with SPS operating that unit potentially up to 4,000 gigawatts a year, correct?
No, ma'am. I'd like to reframe that again, if I may. I think,
Well, can you answer the question I've asked? Is that yes or no? Please, I'd like.
Well, what I'd say is I think the company certainly has authorization, wide discretion to operate plants at the need as they may. I think the company's represented a sort of dismaying number of rationalizations for new costs needed at this plant associated with effectively a resource shift that should have been more widely and effectively evaluated. And under those circumstances, I'd recommend disallowing those costs.
Okay, well, let me ask you, you've been trained as a lawyer, correct?
Yes.
And have you ever operated as been employed as a resource planner for a utility or regulatory commission?
No, ma'am, although I've been involved in a number of those proceedings.
Did you conduct any of your own modeling in this case with respect to resource planning?
Nope. Although I did take a look at the testimony of Mr. Elsie, as well as the analysis conducted in response to that, although it's not a new modeling conducted by the Sierra Club witness.
Did you conduct any modeling with respect to the relative cost savings of operating the Tolk unit at 2,400 gigawatts a year versus 4,000 gigawatts a year?
No, ma'am. I evaluated the modeling and the representations made by the company, and I believe that the modeling here, as well as the inputs to that modeling, importantly, are inadequate.
Okay, so but with respect to SPS's model, you have no controverting evidence or controverting model to offer into the record, correct?
A separate model? No, I think if the company wants cost recovery, it's incumbent on the company to provide adequate analysis, not to rely on other parties for that analysis.
Okay. Did you do any modeling with respect to whether or not operating the Tolk unit at 2,400 gigawatts a year, as CCAE has requested, would impact SPS's ability to reliably serve customers?
Ma'am, I have to disagree with your characterization of my testimony. I haven't recommended a specific operational level. I believe that operations have varied at that plant to some extent. There has been in place a operational plan that targets generation at that level. And to my knowledge, there's no request, there's no information, there's no justification made by SPP that the recommended change and associated cost recovery has anything to do with adequate provision of service. The recommendation, as I see it, has been made by the company based on inadequate modeling that justifies or attempts to justify it based on being more cost effective. I think that leaves leaves out key provisions and key information. Among those pieces of information are that gas prices have come down significantly. Secondly, it leaves out significant existing costs for NOx, as well as significant risks in costs for NOx being increased over time. And it also fails to evaluate the opportunity had a timely request for proposals been submitted for that increased generation to be more cost effectively provided by either new renewables or new storage. In all those instances, I think those failures reflect imprudence and unreasonableness for the requests that are in this proceeding.
Mr. Rowland, I'm going to object as non-responsive. I'm asking you yes or no answers, and so I need you to provide me with a yes or no response.
Ms. Kane, it might be more helpful if you direct your questions to specific areas of Mr. Long's testimony. I believe that he's running on in his answers to you, but if he's not able to identify exactly what parts of his testimony that you're referring to, it might be more helpful.
Certainly.
Go ahead.
Did you point to anything in your testimony, or can you point me to anything in your testimony in which you have identified that there would be lower cost resources other than Tolk to serve customers through 2028?
My testimony doesn't identify specific resources. My testimony laments the lack of evaluation or comparison in the company's analysis. And I do refer.
Mr. Long, answer the question, sir.
I'm doing my best, Judge.
Okay.
I believe that
I think you answered the question, no? Is that right?
Well, I don't know if I use the word no. I think
Okay.
my testimony points to a lack of that available information based on the company's direct case.
I think the question, sir, was, do you identify anything in your testimony that points to some other type of resource that might be more cost effective?
My testimony refers to the testimony of Ms. Glick that notes a number of resources in the region in recent RFPs at lower cost or likely at lower cost, but it doesn't identify any specific resource recommendation.
Okay, thank you. Go ahead, Ms. Kane.
Thank you, Madam Hearing Examiner. Mr. Long, let me ask you, if the limitation, if TOLC is operated under a hypothetical in a limited manner at, let's say, at 2,400 gigawatts an hour, and SPS needs addition, that is insufficient to serve SPS's customers. It needs additional resources, and also assume for the sake of this hypothetical that all lower cost resources have been dispatched, for example, renewables. Would you agree with me that SPS would then need to go seek, production from the next highest cost resource to serve its customers?
The question, if I can't, Madam Hearing Examiner, I'm not trying to drag on. I just want to make sure I'm understanding the hypothetical. The question is, if SPS limits the generation of TOLC, all lower cost resources have been dispatched, and additional demand arises, then what might SPS do?
Well, so
is that the question?
Yeah, so then it's going to have other. Would you agree with me that then it's going to have to look to other resources to serve its customers, correct?
I suppose so, although I'll note that that's nowhere in my recommendation. I have nowhere recommended an operational limit, but yes, I suppose that's right.
So let me ask you, you've said repeatedly you've nowhere recommended an operational limit, but you have recommended that SPS receive no cost recovery for operating TOLC above 2,400 gigawatts an hour. Isn't that correct?
I've recommended that in this case, a roughly $1 million request for increased O&M to target higher generation has not been adequately made and would be imprudent and unreasonable. And I think there have been a variety of proclamations by company witnesses in this case in different directions, sometimes saying it's unlikely to operate that because gas prices are now lower, other times saying specifically the company would target that level of operation and set prices to that level in order to ensure it.
You're not responsive, Mr. Long.
I'm sorry.
I'm sorry, Judge, and I need one person at a time.
Yes, sir.
I apologize for interrupting the witness, but
I understand, ma'am.
I've been asking yes or no questions and not receiving very long answers. May I redirect the question again, Madam Hearing Examiner?
Please.
So, Mr. Long, you've been saying repeatedly that you haven't recommended an operational limit, but is it correct, yes or no, that you are recommending that SPS not receive cost recovery associated with operating the TOLC unit above 2,400 gigawatt hours a year?
Associated with a target change or optimization plan change that I believe has been inadequately justified, yes.
Thank you. Now, did you listen to any testimony earlier by SPS witness Belt regarding SPS's analysis of the water that serves the TOLC units?
Yes, I believe I listened to most or all of his testimony, ma'am.
And you may recall that Mr. Belt indicated that SPS customers have paid and made investments associated with development of the TOLC well fields. Do you recall that testimony?
Yes, I do. I do recall that testimony.
So you have no basis to dispute that SPS customers have made investments related to the water needed to operate Tolk.
I don't, although I dispute the implication that that implies that they should use every available drop or that that would be a prudent use of resources.
And again, yes or no answers, please. Do you agree that the customers of SPS who've made such investments should get the full value of those investments?
I believe that using every available drop is not a good judge of the available value of those investments. I have a long answer there. I'm trying to keep it as brief as possible.
So you don't believe that customers should get the full value of their investments?
No, ma'am, I think you're attempting to mischaracterize my testimony here, if I may. I think that sunk costs in resources like those, including the sunk costs at Tolk Plant, are not best evaluated based on full or complete utilization. I think that a sunk cost is made and customers have paid it. And the question now is whether there are lower cost resources on an operational basis that might save customers money, regardless of whether that water is utilized. I also have very significant concerns about the climate risks associated with attempting to accelerate water depletion at this time in that aquifer based on Mr. Belt's testimony, and I've attempted to raise those in my testimony as well.
But again, you've identified no other you yourself have identified no other lower cost resource other than Tolk, correct?
Ma'am, I have not, and I believe that's exactly the problem. There wasn't a timely RFP to evaluate this resource shift that the company is recommending, and instead they're trying to put the cart before the horse.
Well, let's talk about RFPs. Are you familiar with the IRP process that's currently being undergone by SPS?
I am familiar with it, yes.
Okay, are you aware that there have been a number of stakeholder meetings that have been held relevant to the IRP?
I am, although I've been hardly able to attend them because I've been busy in this proceeding. I hope to participate when I can.
Have any of the IRP stakeholder meetings overlapped with proceedings in this matter?
I believe there have been, well, I'd have to go back and check my calendar, Miss Kane.
Okay, would it be correct to say that you haven't attended any of the IRP stakeholder meetings that have been attended?
I have not yet had time. That's correct. Although I couldn't say as to whether there have been other CCAE parties available and participating.
Okay, so are you aware of whether anybody from CCAE has attended any of the stakeholder meetings?
I'd have to.
I object, Your Honor. This is far outside the scope of Mr. Long's testimony, and on that basis, I object.
Ms. Kane.
He introduced the issue of the RFP, and I'm about to get there. We're talking about RFPs related to
that has nothing to do with CCAE participation.
Ms. Lynch, let her finish her answer, please. Stop interrupting. Ms. Kane, you want to finish your response to the objection?
Thank you, Madam Hearing Examiner. Mr. Long raised the issue of there not being an RFP related to replacement resources for Tolk, which relates to the IRP process. And so that is why I've asked these questions of him, and we will soon turn to the issue of the RFP.
I'm going to overrule it. Get to the subject.
Thank you, Madam Hearing Examiner. Mr. Long, are you aware that the key subject of the IRP process that is currently ongoing is the identification of replacement resources for Tolk?
I am aware, and I believe that's for post-2028 replacement resources. And as I've stated in my testimony, my concern is whether there are resources that might cost-effectively replace some or all of the energy that the company is seeking to extract from Tolk prior to 2028. So while I think that's an important issue and important set of proceedings, I don't believe it's directly on point with the questions that I've raised in my testimony.
Are you aware that SPS also recently, at the end of last year, issued an all-source RFP to seek additional resources to serve identified capacity needs through 2027, I believe?
I am, and I believe that at various points the company has stated that the results from that are confidential, although some results have snuck into recent testimony, but those results were not timely and were not used to evaluate the cost effectiveness of this resource shift.
Are you aware that Mr. Elsey testified in his rebuttal testimony that that RFP essentially produced responses for resources that would only come online until 2026 and 27?
I am aware of that, and that's part of my concern here, is that RFP wasn't issued in time to produce earlier results. Although I'm hopeful that some of that may happen anyhow in 26 and 27. Having not seen the full results, I can't comment.
So given that an RFP, seeking all sorts of resources, if we operate on the assumption didn't produce, potential resources to come online until later this decade, what is your basis for stating that if there would be additional resources available currently in 23, 24, 25?
Well, I think the basis is different in the case of Tolk and the case of Nichols. In the case of Tolk, the high gas price period began, I believe, in 2021, subject to check, and extended well into 2022. And during that period, I presume the company began to develop the plans for higher utilization and changing the target for operations for Tolk. And my view is that at that time would have been an appropriate time for the company to issue an RFP. That's a year or more ago, rather than waiting until, I believe, December of this last year when this RFP was issued, at which point it's possible, although it's also possible that no results would have been relevant or available, but we would know whether or not those alternative resources might more cost effectively replace that increase in generation. In the case of Nichols, my understanding, and this was also testified to by, I believe, Mr. Elsie to some extent, SPP began the process of considering a capacity increase for their reserve margin recommendation or reserve margin requirement approximately a year ago. Again, at which time SPS could have issued an RFP for additional renewables or storage or other resources that might more cost effectively provide the capacity that it is asserting Nichols is necessary to meet. But instead, the company waited until December and has not released any of the results of those RFPs, of that RFP, in any comprehensive manner into this proceeding for parties or for the commission to evaluate. So it's my view that in both cases, an earlier and full evaluation of those might or might not have led to different resources more cost effectively meeting that need. And I believe that the company's failure to act and failure to evaluate certainly should not be an excuse to force the higher utilization of Tolk or the cost associated with extension of Nichols. And certainly I would also, I would say that shouldn't be a justification for having no other resources available.
So it's correct to say then that you don't know that any other resources are out there that would be available to SPS, correct?
Absolutely. Yes. My point is that there's a lack of analysis. That's the point I've been trying to make. Yes.
And then second, you have no basis to dispute that SPS's witnesses testimony that SPS did issue an RFP and that produced no resources that could come online until 2026.
I dispute that that's responsive. I think they certainly did issue an RFP. I don't know the full results of that. I don't believe that the company has released the full results of that RFP into this proceeding, so I can't evaluate it. There have been a couple of comments made by, I believe, witness Elsie, Mr. Elsie, to that regard. But there's been no comprehensive release of those results, and I'm still concerned that the RFP was issued too late to adequately evaluate whether or not these increased costs were prudent or in the public interest.
So let's talk a little bit about the Nichols unit. I know that you've raised concerns in opposition to the extension of the Nichols units to 27 and 28, correct? 27, excuse me.
If I may, Ms. Kane, again, I'm going to make the same adjustment here. I've raised concern with regard to the cost recovery associated with the increased O&M as well as life extension of that unit at this time, given the information that's on the record.
Okay. So again, it would be correct to say that your assertion is that SPS should not receive cost recovery associated with the extension of those units.
At this time, yes.
Okay. Now, do you have, are you aware of the change in the planning reserve margin at the Southwest Power Pool from 12% to 15% in 2023?
Yes, ma'am, I am.
Okay. So you have no reason to dispute that utilities that operate within SPP had to essentially make changes to meet that changing planning reserve margin, correct?
No, ma'am, I agree.
Okay. And are you aware that both SPS witness Trammell and SPS witness Elsie testified that the main reason for the extension of Nichols was to meet that planning reserve margin?
I am aware, and I, raised some concerns about that rationale in my direct testimony. There was further discussion in rebuttal testimony on that issue. And I'm still somewhat concerned with the way that the specific capacity needs and demand forecasting was done in connection with this case. And that is an area that I hope to dive into in this ongoing IRP, Ms. Kane. I think my concerns related to the specifically, and I'll try to be brief here, but the 12 to 15% reserve margin is on top of the expected capacity needed to meet customers. And that's a understandable recommendation or requirement by SPP, but it still doesn't represent the bulk of the capacity need, right? The bulk of the capacity need is based on the demand forecast. And the way that the demand forecast was initially presented in direct testimony, I felt was at least confusing and perhaps inadequate as between the role of the economic evaluation of the demand forecast and then the inquiries from individual customers. And rebuttal testimony addressed that to some extent and attempted, I believe, to make clear that the bulk of the demand forecast recommendation was based on the economic analysis, and that the capacity needs that were requested, including, capacity needs were requested were based on that economic forecast plus the new PRM number, the reserve margin number, planning reserve margin number, and not directly based on specific uncommitted requests. So that's and I apologize, that's a bit long, but the way of what I'm trying to get at here is that you first have to know that the forecast is right, and then the adder, the PRM as an adder on top of that forecast, you can get a sense whether that's the tail and not the horse or not the dog, I guess. And so my concerns were with the way that was described. All of that said, while I'd like to learn more about that demand forecast process, I don't dispute that a increase from 12 to 15% would increase, all other things being equal, would increase the amount of capacity required by the company.
Thank you. And Mr. Long, if you could attempt to answer a yes or no question with a yes or no answer. I have limited time.
Ms. Kane, ask the question.
Thank you, Madam Hearing Examiner. So you don't dispute that SPS would face penalties if it didn't have sufficient capacity to meet the planning reserve margin?
I don't know the specific penalties, but I don't deny that that's likely. I'd have to look up the specific requirements of SPP, but I don't dispute that a requirement is a requirement, and that SPS has to go from 12 to 15% under those requirements.
And would you agree that to the extent SPS needs to obtain sufficient capacity to meet the planning reserve margin, it should be able to recover the costs associated with that?
The reasonable and prudent costs, that doesn't mean any costs, but I do believe that reasonable, prudent costs that are in the public interest should be recovered. My concern is that the evaluation here has been inadequate to justify that.
So let's talk a little bit about NOx costs. Do you have any reason to believe that if the good neighbor rule were to ultimately be implemented, that SPS may have to purchase additional NOx allowances to operate certain of its resources if the generation exceeds its available allowances?
It may, depending on the operational decisions made by the company. I think that could vary widely.
And are you aware that SPS has current obligations under Casper Group 2 that requires it to have sufficient NOx allowances, and it may need to purchase additional NOx allowances, even if the good neighbor rule doesn't go into effect?
I'm not I didn't testify to the specifics of that program, but I acknowledge that Ms. Trammell recognized that there had been approximately $2 million of costs in 2022. I think it was $1.8 million of costs. And that issue I did raise in my testimony with regard to my concern that ongoing NOx costs and the range of NOx possible costs were not evaluated in the request to recover costs associated with increased O&M for increased generation at Tolk.
So with respect to to the cost of NOx and as it relates to operation of a resource, did you have a chance to listen to, and I cannot recall the witness at this time, who testified, I believe it was Ms. Trammell, that, you know, if SPS was required to purchase additional NOx allowances, that there would be adders that would be adjusted on the dispatch to the pricing of Tolk that would affect its dispatch to account for those additional costs?
So I believe that two different witnesses testified slightly different things in this regard. Ms. Trammell and Mr. Elsie. Ms. Trammell's testimony, as I recall, said that the company would work with the market monitor to set the price for Tolk to achieve the target level of generation. I didn't hear in that response the claim by Ms. Trammell that would vary based on NOx costs. Mr. Elsie did say that NOx costs would be added to dispatch in his cross-examination.
Okay, so just focusing on the NOx adder aspect. So would you agree that if there are additional NOx costs that have to be accounted for in the pricing of Tolk, that could then affect its dispatch, and it may be dispatched less if it's priced higher?
I would say that I have very significant concerns with what I heard from witnesses on SPS, and I am left somewhat confused about the specific plans for inputting Tolk into dispatch decisions at SPP as a result. And those magnify my concerns about potentially unlimited NOx costs being passed on to customers.
Okay, can you explain what you mean by concerns?
Yes, specifically, Mr. Elsie, I believe, testified quite adamantly that Tolk would only be dispatched to the extent that it was economic, regardless of any costs recovered for increased O&M or the opportunity to recover NOx costs. But Ms. Trammell, I heard to say that the company was quite certain that it would achieve the target level of generation being proposed here, about 4,000 gigawatt hours a year, and that the company would work with the market monitor to ensure that dispatch achieved approximately that target. And that answer, to my mind, was concerning in its lack of inclusion of both market implications in terms of various costs of resources, costs of gas versus coal, as well as the implications for whether or not NOx costs would be included.
Are you familiar with the concept of economic dispatch in an SPP market?
I am.
Okay, so it's your understanding that if a unit is offered in for what I believe was described as market commitment, that it shouldn't get dispatched unless it is kind of, you move up in the stack from least cost to higher cost, that it wouldn't be dispatched unless it qualifies as within that kind of lowest cost unit available to meet demand, correct?
Again, I'm going to say that comports with my general understanding of dispatch under SPP or other organized markets, but I believe that to be inconsistent with what I heard from witness Trammell, which was that the price would be set working with the market monitor to achieve the target level of generation. And I believe that that's consistent with what she said has been done under the current optimization plan to achieve approximately 2,400 gigawatt hours a year. And then that is what would be done under 4,000. Now, if I misunderstood, and that's not the case, I still have concerns with increasing cost recovery for O&M for this plant, because I don't think the company's made the case that the analysis shows that that's necessary or prudent or in the public interest for all the reasons I set out in my testimony, including climate risks and water risks and failure to evaluate alternatives. However, I'll be happy if that's the case, because the climate emissions will be lower if it's only dispatched economically, I believe. But I have concerns that the company appears to have rationalized the change both ways.
So let me ask you, are you familiar with the provision in the stipulation that limits the conditions under which SPS can self-commit the Tulk unit?
I am, and I support those, include the inclusion of those, but I don't believe that prohibits, as Ms. Trammell noted, working with the market monitor and SPP to set the price for the unit. And if the price is set at the unit to reflect a dispatch target, then I suppose the placidity of that price could mean that the plant is operated more or less.
But a unit could be priced a certain way, and it's still up to the economic dispatch mechanism to decide whether or not that unit is dispatched based on whether or not it is the lowest cost available unit at the time, correct?
Well, if it's priced in such a manner to target that level of generation, I suppose the point would be to price it to get to that level of generation. But yes, I mean, once the price is set, and I'm not deeply familiar with the interactions that have been portrayed by the company with the market monitor in terms of how the price is set at the unit. But I have some concerns about how those have been portrayed.
So you're not suggesting that SPS would somehow manipulate a price to dispatch a unit in a way that's not indicative of the actual pricing of the unit.
I'm not attempting to accuse SPS of market manipulation. That's not my intent here. I'm just reflecting what I've heard by the witnesses in this case, which is that I heard the witnesses to say that the price would be set to reflect the target level of generation.
Okay. But you have no basis to dispute Ms. Trammell's testimony that the unit would be offered in for market commitment,
as opposed to the other types of commitment that are prohibited in the stipulation. Yes, that's right. But I also don't believe, based on her own testimony, that prohibits working with the market monitor to set the specific price.
Are you familiar with the SPP market monitor?
Like I said, I didn't provide deep testimony on that issue. I've only mentioned the company's testimony on it. I haven't worked with in SPP in depth, and I haven't worked with the market monitor. So I wouldn't consider myself deeply knowledgeable on the market monitor, which is why I'm only raising questions here and concerns based on what I view inconsistent rationale for this cost recovery.
To the extent you have concerns about the NOx costs associated with Tulk unit, would you agree that there's mechanisms available under the New Mexico rules that would allow for a prudence review if those costs are recovered through fuel?
I am aware that the fuel clause can be reviewed for prudence. I suppose I'm not an expert into the specific requirements around such a case and whether supporters of a settlement, which are most of the regular stakeholders here at the commission, would be precluded from challenging the prudence of a component should they support a settlement that guarantees its inclusion in that clause. But I do understand that those cases exist and that costs can be challenged in the fuel clause.
And there's nothing in the stipulation that you're aware of that precludes any signatory of the stipulation from raising a prudence issue down the road, correct?
Well, that's typically participants to a settlement don't then challenge elements of that settlement. in that case or future cases, but I'm not aware of a specific prohibition in this case.
Let's talk a little bit about the ETA. You cite to some language that I believe speaks to reasonable and consistent progress over time, correct?
I do.
Okay. And with respect to that language, it's included in provision the ETA that speaks to no, essentially carbon-free resources, 100% carbon-free resources by 2045. Is that correct?
Yes, that's correct. It's in a list of requirements for increasing renewable energy, the last of which is 100%. The last of those requirements gets to 100% by 2045, and then requires reasonable and consistent progress over time towards that objective.
Are there any interim percentages or goals with respect to carbon resources between now and 2045 in the statute that you're aware of?
Other than the requirement for reasonable and consistent progress towards that target, and the renewable energy targets, which imply carbon.
Sorry, just a moment. Other than the requirement for reasonable and go ahead.
Reasonable and consistent progress over time, and the implications of the increased renewable energy requirements over time. I don't believe there is a specific interim target for carbon-free energy acquisition in the law.
But there are incremental goals with respect to how much of a utility's retail sales come from renewable energy. Is that correct?
Yes, that's correct. Although if the implication is that those obliterate or obviate the meaning of reasonable and consistent progress over time, then I disagree.
Let's speak just about, without regard to implications. Would it be correct to say that the ETA has a goal of retail currently that utilities use, make at least 20% of their retail sales from renewable energy currently?
We can go through these quickly if you'd like. 20% by 2020, 40% by 25. Well, actually, maybe you should remind me. I'm going to have to open it up to make sure.
Okay. Let's just speak about the current goal. We both agree that it's 20% currently, correct?
Yeah, 20% by 2020. Yes.
Okay. And if I represent to you that it's 40% at 2055, do you have any reason to disagree with that?
Sorry, did you say 2055?
40% at 2025.
Yeah, that sounds right. Yes.
Okay. Are you aware whether or not SPS is currently meeting those standards?
My understanding is that SPS should be allotted for meeting and beating that standard in the early years, and will still be meeting it by 2025 based on the recommendations in this case, although just barely so. And then whether or not they meet the 2030 number will depend on any renewable energy acquired between now, I should say, and 2030.
You got 5 minutes, Ms. Kane.
Thank you, Madam Hearing Examiner. And with respect to the ETA, are you aware of a kind of corresponding section to the ETA that talks about what the commission should take into consideration when administering the ETA and to reach the 2045 goal? And specifically, are you aware that the ETA says that the commission needs to take into consideration reliable operation and customer electricity bill costs in administering that portion of the EPA that has a 2045 carbon-free goal?
Yeah, absolutely.
So when the commission, would it be fair to say that when the commission is looking at how utility is conducting its operations with an eye towards meeting the ETA's goal, it should take into considerations things such as whether or not the utility has sufficient capacity to reliably serve its customers?
Yes, although it shouldn't, that's not a rationale to include any and all costs in the name of capacity.
But would you agree that the ETA also requires the commission to take into consideration the impact on customers' bills and how a utility may go about conducting its operations to meet the ETA's carbon-free goals?
It is, and indeed the concern about customer bill impacts from the proposals in this case has been at the heart of my concerns and recommendations.
So to the extent SPS's position is that operation of the Tolk unit is the most economical way to serve its customers and would result in approximately $100 million of savings to its customers. To the extent the commission were to accept that may be a factor it would weigh in evaluating whether or not SPS's proposals are in conformance with the ETA?
It would be. I would reject that rationalization, but if it agreed with the SPS and rejected the concerns that I've raised, then of course the commission would have to evaluate the information it sees fit.
Let me ask you, have you ever participated in any of SPS's renewable portfolio standard proceedings?
I don't believe that I've been asked to be an expert in any of those cases. I have looked at a number of the cases.
Are you aware that SPS in the last 2 years has made requests to exceed the renewable portfolio standard and receive an incentive to do so?
I'm not aware of requests for new renewable additions beyond the ones that have already been approved. I believe at Hale and Sagamore in particular in the last 2 years, but you could illuminate me.
Okay. Well, I'm just asking if whether or not you're aware of SPS's request to exceed the RPS standards in the last 2 years.
Exceed the RPS standard more than it already does?
To be more specific, are you aware of SPS's incentive proposals in the last 2 RPS proceedings in which it proposed to retire more renewable energy certificates than required in order to exceed the RPS standards?
Okay, now I think I'm understanding. Yes, I believe I'm aware of those proposals. They wouldn't add new renewables, but they would retire more RECs associated with the renewables the companies acquired. Is that correct? Am I getting that right? Yes, I'm aware that those exist. Although I'm not deeply acquainted with those proposals.
Okay, and you didn't participate in support of either of those proposals, is that correct?
Well, I haven't been asked to be a witness for SPS, but I suppose it might still happen.
Would you support SPS's proposals if it were to make similar proposals in the future?
I'd have to look at the details of those requests, but I do support early action to meet renewables requirements.
Okay. And just a final set of questions. You do not oppose the retirement of Tolk in 2028, correct?
I believe that as specifically proposed, the retirement date poses additional risks and doesn't increase environmental benefit, unfortunately, from the later retirement date. Although all things being, if those concerns are addressed and SPS doesn't increase operations, doesn't more quickly deplete the water resource, doesn't increase NOx generation, then I think those risks are sufficiently mitigated, and a 2028 date would definitely be in customers' best interests as well as in the public interest.
Last question, Ms. Kane.
Thank you. So just so I understand, because that is slightly different than I understood your testimony. All things being equal, is your current recommendation that the Tolk unit keep its current retirement date or at 2032?
My recommendation, to be clear, is to deny costs associated with increased operations, and that to the extent that is denied, the costs are associated with increased operations and the unlimited NOx costs are denied, that would mitigate the risks associated with lack of identified replacement resources that is currently quite high, given that the water is scheduled to be unavailable after that date.
Answers the question at all.
If that is mitigated, then I would support the date. If it's not, then I have concerns that date increases risk to customers.
And the result would be that the Tolk would stay, the current operation date of 2032 would remain.
if that is, yeah, I think those are two options available to the company, to the commission here.
Okay, Ms. Kane, your time is expired. I think it might be appropriate before we begin with the next cross-examiner to take a brief recess. Mr. Lee?
Yes, Judge.
It's 3 o'clock. We'll recess until 3:10. Thank you.
Judge, are you there?
Yes, sir.
I would ask that you request the witness to breathe when he's speaking.
All right, can do. Absolutely.
I'm ready when you are. Good.
All right, sir. We are back from our recess. And I believe, according to our order of presentation, Ms. Drake, you indicated that you had reserved 10 minutes. Do you have questions for Mr. Long?
Not at this time. Thank you, ma'am.
Very well. How about you, Major Buchanan? You had indicated that you had reserved 10 minutes. Do you have questions for Mr. Long?
I do not, Madam Hearing Examiner. Thank you.
Very well. Mr. Smith, you had indicated that you had reserved 10 minutes for Sierra Club. Do you have questions?
Thank you, Your Honor. I have just maybe a couple of clarifying questions, if I could.
Okay, and before I set your time, Mr. Smith, there's been a request, Mr. Long, that you slow down in your testimony when you're answering, please.
Yes, ma'am. And I believe I've worked with Mr. Lee before, and I meant to apologize in advance. I tend to speak too quickly, and I apologize. I'll try to keep it front of mind.
Okay, all right. Go ahead, Mr. Smith.
Thank you, Hearing Examiner Hurst. Good afternoon, Mr. Long. How are you?
Good afternoon, Mr. Smith. I'm doing just fine.
Great. Thank you. On your cross-examination with Ms. Kane, you'll recall some back and forth about NOx prices and whether those prices would be incorporated into the company's offer into SPP. Do you remember that line of questioning?
I do.
Let me ask you sort of a follow-up hypothetical on that line of questioning. There was some uncertainty about whether those prices would be incorporated. If those prices were incorporated into the company's offer for the Tolk units into SPP, all else being equal, would you expect those units to run less frequently?
Additional costs, yes, I would suppose would reduce dispatch, any additional costs.
And in your view, would that reduced operation be a good thing for emissions from the units?
I'm sorry, there was a little interruption there, Mr. Smith, if you could repeat the question.
Yes, sir. And I'll slightly rephrase it. Accepting that the units would operate less frequently if those NOx costs are incorporated into the offer, would you agree that that reduced operation would be a good thing for emissions and the climate?
Absolutely, and for local air quality as well. The purpose of NOx costs is to internalize those externalities, the externality of the health impacts and air impacts associated with NOx emissions. So inclusion of those costs and therefore reduced dispatch would absolutely be a good thing.
Okay. Thank you, Mr. Long. That's all I wanted to clarify. Thanks.
Thank you.
Thank you, Mr. Smith. Mr. Bagatko,
Madam Hearing Exempt.
I believe you reserved 20 minutes.
I
to
did,
ask
but
questions.
My questions now would be duplicative or are now obviated by largely Ms. Kane's efforts. So I don't want to waste people's time, but so I don't have questions for Mr. Long now, but we do thank him for his participation today, and I would pass the witness.
Thank you. Is there any other party that I didn't note that had questions for Mr. Long? Okay, I don't see anybody else. Thank you, sir. I have a few questions for you. I think I understand your testimony, but a few clarifications. I noticed in your direct testimony, SPS, CCAE Exhibit 1, that.
I'm sorry.
Hang on just
Judge,
a second.
if I may, I interrupt. Well, just that CCAE Exhibit 1 is not my direct testimony. That's my testimony in opposition to the, and so I'm just trying to make sure I refer to the right.
Oh, sorry, I
document.
was looking at my printed copy. I did not change. It was initially labeled as CCA Exhibit 1. And so you are correct. I am looking at CCA Exhibit 2.
Okay, and apologies for interrupting.
No, it's good for me to mark the mark in my notebook. So looking at CCA Exhibit 2, and I thought I was going to sneeze. That's why I stopped my question. So in looking at that, on page 5, you pose the question at line 3, has SPS's plans for the toll generating station changed? And you start out on line 4 and you answer yes, and then you continue with your answer.
Mm-hmm.
And at line 9, you say, SPS's new plans are to run Tolk year round and increase its annual generation. That's your testimony, sir?
Yes, ma'am.
Where in SPS's application and or its witness testimonies does it say it plans on running Tolk year round and to increase its annual generation?
I'd have to check on the page number if I may, Judge, but that I believe can be found in Ms. Trammell and Mr. Elsey's testimony referring to the change from a target generation level of 2,400 to a target generation of 4,000 gigawatt hours per year. The specific page numbers I would have to pull up. You want me to try to do that?
No. So you're evaluating Tolk from a scenario of 2,400 gigawatt hours annual generation to an increase of 4,000 gigawatt hours annual generation, but with a shortened life to 2028 instead of 2032, correct?
Yes, that's correct.
Okay. And can you point me to where in the stipulation it says that the parties have agreed to a annual generation of 4,000 gigawatt hours.
I can pull up a line. Madam Hearing Examiner. I believe that the agreement and the stipulation is to allow increased O&M expenditures. There's not as I was attempting to communicate in the previous questioning, it's not an agreement to a specific operational level. It's to increase O&M expenditures consistent with that plan, which has been referred to in the company's direct application. If you'll give me a moment, I can pull up that reference.
Well, what I heard in the testimony last week from the SPS witnesses was that they were proposing to potentially increase the generation if SPP found that it was economic to do so. So that's they had a witness tell me, we're not asking for any specific operational amount. What we're asking for is to be able to operate it as long as it's economic.
Yes, Judge, I believe that was, I'm sorry, I didn't mean to interrupt.
Well, so I'm just wondering if I just missed something in the stipulation that says, oh, and by the way, we want to operate now at 4,000 gigawatt hours.
So if I may, I believe there's a couple responses there. First of all, as I said earlier, the stipulation includes reference to an inclusion of roughly $1 million in additional O&M costs plus unlimited NOx costs in the fuel clause, which might have previously acted as a limit on TOLC generation. With regard to the SPS testimony over this past week, as I said earlier, I heard two different things there. I agree with you. I heard witness Mr. Elzy, to say, I'm not going to quote the specific words, but very consistent with what you've just claimed.
Right, and I've heard you tell me that on the record twice. So I don't need to hear the distinction again between Ms. Trammell's and Mr. Elzy's testimony, because the record's going to say what the record says.
Okay.
But I'm just trying to figure out, since in your testimony you talk about this, the costs associated with this generational limit. I'm just wondering, like you say, did I miss something, Mr. Long? And is that limit specifically in the stipulation?
Again, there's not a limit in the stipulation. There's two requests for costs that would be implicated with increased generation, and those are justified in the direct case as associated with that target change.
Okay. And one of those you're referring to is Section 8, which is the NOx allowance cost, which removes the cap.
That's right. That's one. And I knew I should have looked up the stipulation while you were referring to the other one, because then I would have it for you now. But let me find the other for you.
And I think the other is potentially subparagraph 7 in item 1, which is agreement to base rate increase, which says in the second sentence, the signatories agree the estimated incremental O&M expense associated with continued flexible dispatch is $980,823 is reasonable. Is that the other section you're looking at, sir?
Did you say section 7? Yes, I believe so. And it's itemized, discussed in section 9 of the stipulation.
Yes. So those are the two sections in the stipulation that you believe would authorize SPS to change its plan of operation to a limit of 4,000 gigawatt hours annually.
That's correct. Those are the costs associated with that. I don't think there's a specific requests pertinent to the case about the operations per se. It's more about whether the commission authorizes costs associated with that target change. The specific operations are at the discretion of the company and subject to their operation in SPP. Although the limits of there are limits, of course, on certain commitment types that are in the settlement.
Well, and depending on what the costs may be, if the costs were such, even if it was economically dispatched, it could actually depending on what the costs are and how often it's dispatched, it's going to reflect on how often it's operated, correct?
In general, I would agree with that assertion, although, like I said, I heard Ms. Trammell to say that the price would be set with the market monitor to ensure that level of dispatch.
Another question, sir, I had about SPS Exhibit 2 in you're answering the question posed at page 6 and the line 11. What are your concerns about SPS's talk plans?
I'm sorry, you said SPS Exhibit 2. I'm assuming you mean CCAE Exhibit 2.
CCAE Exhibit.
Okay, I apologize.
Yeah, CCAE Exhibit 2. And I want to focus in on your answer at page 7, where you say lines 1 through 3. Second, New Mexico's renewable portfolio standard requires utilities to demonstrate consistent progress toward greater renewable energy reliance in an effort to consistently reduce emissions. That's your testimony?
Yes, ma'am.
Where specifically does the RPS requirement state consistent progress toward greater renewable energy reliance in an effort to consistently reduce emissions?
If your question is that, does it use those specific words? It does not. That is my paraphrasing of 6216-4, which we've discussed. And I believe that the requirement for reasonable and consistent progress is additional to those incremental requirements for renewable energy.
You had indicated in response to Ms. Kane's questions about the last 2 renewable portfolio standard cases And I think she asked you if you participated and you said no. Is that
That's correct.
correct?
Yes.
Were you familiar at all with those cases?
I am at a high level. But if you're going to ask me details, I might need to really refer to
Okay.
specific documents.
And I'm just going to ask you, I think she asked you generally whether or not you were aware that SPS had applied for incentives to exceed.
Yeah.
And you had indicated, I'm aware that SPS proposed to retire additional RECs.
Yes.
Is that right?
Yes.
Do you know that potentially the SPS's RPS case (21-00172) is on appeal, and that one of the issues has to do with SPS's request for incentives?
That rings a bell. I'm not participating in the appeal.
Okay.
Or nor did I participate in the direct case.
Okay. Mr. Long, on pages 16 and 17, I believe you're providing testimony about the Energy Transition Act. And on page 17, the question posed at line 6 through 8, are SPS's TOLC plans consistent with what the legislature was trying to achieve with regard to out-of-state coal plants that serve New Mexico customers? And you begin your answer, not entirely. Again, you use the word consistent with what the legislature was trying to achieve. Is there any specific reference in the Energy Transition Act that references consistent performance?
The renewable energy standard portion that we referred to earlier was that amendment was included in that broader act. It's a bit confusing because folks refer to the ETA as both the broader statute as well as the specific act that is now in code. So I suppose that in chief, I was referring to the renewable energy standard components that we just discussed, and I won't recite again. Although I also do reference in my testimony the inclusion of the incentive and mechanism for decarbonization in the attempt to demonstrate a broader attempt by the legislature to encourage rapid decarbonization by the utilities. So that's what I was referring to there. Although I do also believe that the elements related to the retirement of New Mexico coal plants was also intended to create one mechanism whereby some facilities might be more quickly retired to benefit of customers and the environment.
But the specific statutory reference is not what you're referring to in line 6 through 8, the question.
I'm sorry.
You were talking about the broader policy in your answer.
Yeah, I mean, I think that in 6 through 8, I referenced 62-16-4. Is that what you're referring to there? Am I in the right spot?
No, I'm looking at
Okay, I'm
page
sorry.
17 and the question posed at line 6 through 8 about Tolk's plans consistent with the what the legislature was trying to achieve. Your answer at lines 9 through 12 is basically talking about the policy, not the specific statutory reference, correct?
My answer there is referring to both that specific statutory reference and other elements of that broader policy, which I believe were intended to achieve that goal, as justification for what the legislature might have meant, in particular when they said reasonable and consistent progress, which I think has to be interpreted and and executed by the commission.
And moving on to your testimony at page 18 and the question posed at line 6 and 7, what are your concerns regarding SPS's request to extend the service lives of Nichols? You talk about your concern with the capacity reason for being the request, and at lines 9 and 10 you say, and 11, SPS's future capacity position is reliant on their load forecasts, which are not reliable enough to make decisions about extending the service lives of Nichols 1 and 2. That's your testimony, sir?
Yes, ma'am.
And are you an expert in load forecasting?
I've done quite a lot of work over the years on load forecasting from utilities, never for a utility, but I participated in a number of cases and policy issues related to load forecasting. So in this case, I evaluated the load forecast. And as I said earlier, I do think that SPS's rebuttal testimony addresses some of these issues, but I think there was a cloudiness as between the specific economic forecasts and the requests by individual customers that were not committed requests for load expansion. In the rebuttal testimony, SPS does assert, and I have no reason to believe they're wrong, that the forecast that they're relying on for their specific capacity resource needs are based on that economic forecast, which I do think addresses some of the concerns that I had here, but were not clear in the direct testimony.
So in CCAE's Exhibit 4, the statement in opposition, it is indicated that SPS opposes Section 1, Section 4, Section 8, Section 9, and Section 17 of the stipulation. Is that right?
You're on mute.
I'm sorry, I didn't mean to go on mute. I was just saying that I was just attempting to navigate to that document, but I believe I closed out the file instead of opening it. So it will take me just a bit longer than I expected. But I have, subject to check, I have no reason to dispute your assertions on the statement of opposition, Judge.
In CCAE, Exhibit 1, your testimony in opposition to the contested stipulation. If I could characterize them, you have 6 recommendations or groups of recommendations that are what you would propose would modify the current stipulation, correct? Beginning
Subject to check. That sounds plausible. And if you could refer me to a page number, I'm happy to confirm.
Sure. I'm on page 3 of your CCAE Exhibit 1. What are your proposed recommendations, modifications to the current stipulation?
I'm sorry, page 1.
Page 3.
Page 3. I apologize.
Here you go.
Are you going to pull it up there?
I am.
Yeah. That's
Okay.
my testimony.
So the first one is you're recommending that the Tolk be retired in 2028, but no changes in the current operating plan of which you indicate is an availability to run at 2,400 gigawatts per hour, correct?
Not quite, Madam Hearing Examiner. No additional customer funds in support of that plan. I don't believe they've requested authorization of the plan per se, but they have requested 2 areas of funds to support that change that I oppose.
Okay, I hadn't gotten to your second recommendation yet. Is that?
No, but
So
even in the first, if I may,
Okay.
I say I recommend that no further.
No customer funds. Okay. All right, so retired it in 28, no more funds for increasing, using it more than the 2,400.
That's correct.
Okay. And then second, you are recommending that the SPS Unlimited, so the removal of the cap.
I recommend not removing the cap on NOx.
Right.
Yeah. Yes.
What and blah, blah, blah. Do you object to the payment of NOx allowances through the FPPCAC?
Yes. And
Okay.
the removal of the limitation.
Right, and the cap. Okay. So plus the FPPCAC plus. Okay. All right. Then 3, you recommend that Tolk actually reduce emissions as it approaches 2028, and that it identify resources that are going to be online at that time of retirement, correct?
That is correct, Madam Hearing Examiner. And
Okay,
I'd be
so
happy to
that's
elaborate
a
if you'd like,
twofer.
or happy to not if you prefer that I don't.
Well, I'm just wondering if you are in agreement in 1 that they can have the funds to utilize at 2,400 gigawatt hours, then how are you also going to, how does that work with reducing emissions as it
Yeah, that's a fair question. It's and a good one. Again, the funds are associated with an operational target. And I'm not recommending the commission set specific operational requirements on Tolk that would reduce its operation over time. However, I do believe that the changes I've recommended, including early acquisition of renewables and demonstration of reasonable and consistent progress, would likely lead to the outcome of reduced emissions from Tolk. Because as Mr. Elsie testified, when new renewables are added, they're first in the dispatch stack, and they tend to reduce emissions across the board, but in particular from higher cost resources. And Tolk tends to be a higher cost resource, particularly when gas prices are low. Now, of course, that can change, but that's traditionally or often been the case in both SPP and the Western Interconnect. So I think that those changes in requirements would likely lead to that reduction of emissions over time at Tolk towards its retirement date in 2028.
Okay, so the reducing emissions is tied into the identification of the replacement resources.
It's related, as I believe Mr. Elsie or others have testified, replacement need not happen all at once. As new renewable energy resources are identified and brought onto the system in, say, 2025, 2026, 2027, that may well reduce the need for other facilities and likely the need for Tolk over time. And as those resources are identified, and therefore they are partially replacing, although not completely replacing, the facility. And if I may, I'd like to elaborate on my specific concerns there about the risks associated with running at a higher level through 2028, but I don't want to go off course if you're wanting to go somewhere else.
Well, I'm still just trying to identify what exactly it is you want Mr. Long, the commission, to do, and how or if it relates to one of the other 6 things that I've seen that you want to do. And again, just 6 generally, because a lot of these are twofers. First one's a twofer, the second one's a twofer, the third one's a twofer. And I'm just wondering if the first part of what you want in 3, reducing emissions from Tolk, you've said it is related to the second part, which is identifying the replacement resources by the time, well, you want them online by the time that Tolk has retired. And I specifically ask you whether or not reducing emissions was related to the second part of number 1, which is no increase in the customer funds.
I'd say yes. I
And
mean,
I
the first
guess-
part of sorry, I thought you were done. I'm sorry. I didn't mean to cut you off.
No, now that I look at it, you say no further customer funds be authorized for increasing the utilization above the current level.
That's correct. Yeah.
But you're not opposed to increasing customer funds if it's going to reduce emissions. Is that right?
I'm not aware of any proposals in this direct case or for that matter in the settlement that would propose to use customer funds to reduce emissions. As a general matter, I'm open to those but I don't think it's an issue here. I guess what I'm trying to get at there, if I may, Madam Hearing Examiner, is that the first step to decreasing emissions is to not increase emissions. And the proposal here is for customer funds for an O&M plan and target utilization level that would increase emissions in the near term and obliterate any environmental benefit of a nearer term retirement if that target is met. Now, it's possible that the target won't be met, but then you've just then the commission takes the risks of authorizing funds for increased O&M for generation that isn't needed and doesn't happen. So in both cases, I think it'd be prudent to not authorize that increased O&M costs as well as the increased NOx costs.
Okay. Number 4, you're recommending that SPS has to assure customers it will not plan to deplete all the economical water available to it by 2028, correct?
That's right. That's right, Madam Hearing Examiner. And this relates to the metaphor used earlier about driving a car to Albuquerque, I believe.
And it's SPS's car though, isn't it?
Well, the customers are paying for it and the risks fall on customers significantly.
But it's if I recall the testimony correctly, the well field is the water rights and pretty much most of the well field is either leased or owned by SPS, isn't it?
It is owned by them, but I still don't think that increasing depletion rates at this juncture, given what we saw on that slope of the curve from Mr. Belt's testimony, I believe it's on page 11, would be prudent.
Okay. And then we go on to page 4, and you're recommending SPS at beginning at line 2, and these are recommendations regarding Nichols. I recommend SPS be allowed to seek necessary variances as it did to commence its IRP in 2023 rather than 2024 to add feasible new renewable resources for Tolk and Nichols if it can cost effectively reduce operations at either facility through increased clean energy procurement. Okay, so that's what you would like to see the commission order SPS to do as your recommendation 5, correct?
Yes, that's correct.
And
Prior
then
to
on
cost recovery for those plants.
and then line 6, you recommend that the stipulation include an energy affordability program, EAP. Is that correct?
Yes.
Did you include in your testimony or as an attachment, or did the other CCAE witness lay out such a program?
No, I didn't. And I don't want to testify to his testimony, but my recollection is more that that CCAE and that witness supported the inclusion of such a program and the development of such a program, but I don't want to testify to his testimony.
Okay.
If that's...
But you're making a recommendation that a program be included. And so
right.
what are the details of this program that you want the commission to include?
I apologize. My recommendation here was intended to convey the development of such a program, not the inclusion of a specific program.
Okay, so your recommendation is that the commission order SPS to develop such a program?
Yes, I mean, the direct case from SPS initially included the proposal to include such a program, and that was excluded from the settlement. And I believe I heard an SPS witness testify that they wouldn't oppose, although they can't speak to the broader settling parties implications, they wouldn't oppose the inclusion of an EAP program, and I believe that would be in the public interest.
Well, and I believe first thing out, you indicated that you're an attorney, Mr. Long.
Yes, ma'am.
Did you see the citations from the staff and I believe at least the Attorney General witnesses that said something to the effect of requiring by statute and by precedent that requiring all the ratepayers to pay for a discriminatory rate for one ratepayer was prohibited?
I don't believe that an EAP is necessarily or per se discriminatory. And I do believe that it is in the public interest. So I may have disagreements with their testimony on that. And I suppose SPS may have too, in that it included it in its initial proposal in this case. I suppose those issues could be further discussed were the commission to order the company to develop such a program.
Mr. Long, as part of your job description or as part of your affiliation with CCAE and other proceedings in New Mexico, do you have an opportunity to keep apprised of proposed legislation in New Mexico?
I do, ma'am, although I wouldn't claim it's encyclopedic. There's a whole lot of bills introduced in New Mexico.
Well, did you pay attention this last legislative session?
Yes, ma'am. I tried to.
Okay, were you familiar with House Bill 218 and Senate Bill 432? Both of those I would represent to you are were low income public utility rate proposals, and my understanding is that neither one of those was passed. You familiar with those?
I believe that I am. I'm terrible with bill numbers, but I recall the existence of those bills, and I agree that neither passed.
Okay. All right, and again, just for the record, the CCAE has not actually attached any type of low-income program alternative to recommend to the commission in its opposition to the stipulation.
I certainly haven't, Madam Hearing Examiner. If you there may be a question for Mr. Batts, I believe is how you pronounce his name. I believe that the recommendations he made were to support the company's proposal, largely, perhaps with some modifications, but I don't have those in front of me.
Okay. Do you have any other recommendations to the stipulation other than these 6 that we've just gone over?
I don't believe so. I believe that covers it. Thank you.
And if the commission were to adopt some or all of your, well, let me put it this way. In order, if the commission adopted all of your recommendations / modifications to the stipulation, would you be supportive of the remainder of the stipulation offered in the case?
Madam Hearing Examiner, I didn't make opinions on many elements of the case, so I suppose CCAE would have to decide holistically. But I suppose these were the issues that we focused on, and these are the modifications we're hoping to seek, not some other hidden list, if that's what you're asking.
No, I guess what I'm just trying to figure out, sir, is that what alternatives, if any, the commission has, and the stipulation, and you probably heard yesterday, I think in response to some questions from your counsel to the staff witness, Ms. Labor Tercero, asking about whether or not there could be a modification to the stipulation. And it was pointed out that there's language in there that says the stipulation is the stipulation. But that if there were some proposed modification, if all of the signatories agreed to it, then potentially, then there potentially could be a change. And so I'm just wondering from your position, if the commission adopted all of your modifications to the stipulation, whether that would be enough for CCAE to change its position and support the remaining parts of the stipulation that weren't changed or excluded based on your recommendations.
I think the best answer I can give, if I may, Judge, is that I think if the stipulation were to be modified to include some or all of the recommendations we've made here, we would look at it holistically, or I would recommend that CCAE look at it holistically, and certainly my views would change on it holistically. Whether or not we would take positions at this juncture on specific other elements that we haven't previously taken positions on, or that I haven't testified to, I think that's unlikely that we would take specific positions, but I would imagine it would affect our overall support of the package. Does that help? I'm trying to be as responsive as I can.
No, and I think you've answered the question, sir. I mean, obviously you were part of the negotiations, and your concerns were not met, or you would have joined the stipulation in the first place, right?
That's right.
So now, you've opposed it, but in your testimony opposing it, you're saying, well, okay, there it is, and I changed this, this, and this. And so I'm just trying to ascertain if they changed this, this, and this, is that going to be enough to address your concerns to where you would support it? Or basically, these are the recommendations you would make, so you think perhaps it ought to be rejected and start again?
I guess what I'd say is, speaking for myself as a witness in this case, if these concerns were addressed through modification, my concerns would be addressed, and I would no longer be in a position to oppose the stipulation. If they're not, an alternative is to reject the stipulation if the commission prefers not to make individual changes to the stipulation.
Okay. Very well. I think that answers my questions, Mr. Long. Thank you for your time, and I will stop the share so I can go back and look at people again and say, Ms. Lynch, do you have any redirect for Mr. Long based upon cross-examination or my questions?
Yes, hearing examiner, I have a handful of questions.
Okay, go ahead, please.
Okay. Mr. Long, the first questions relate to the questions that hearing examiner Hurst posed for you. To begin with, I'd like for us to take a look at section 7 of the stipulation, the self-commitment language. In your expert opinion, do the 3 requirements in section 17 of the stipulation for self-commitment represent a reasonable limitation that is in the public interest for the dispatch of tolk?
My view is that those are reasonable and in the public interest, but likely insufficient given the other requests in the case regarding the increased O&M costs and unlimited NOx costs. So insufficient to make the stipulation in the public interest, but those specific limitations are in the public interest.
Thank you. And in your opinion, is it reasonable to require replacement resources for Tolk to be online in 2028?
I'm going to try to be as direct as I can. I think the requirements under the statute here require a holistic analysis of the impacts to customers. And in this instance, where the company is proposing to speed up its depletion of the aquifer such that based on their target generation level, there would be no further economically recoverable water in 2028. That poses a risk to customers that the facility would no longer be available for a matter of months or a year should replacement resources be delayed. And given that the company has not yet identified those resources, I think that this plan creates greater risks than the status quo to customers and no environmental benefit. So under this circumstance, I think the failure to identify resources is damning to the proposal. But I think it's a fact-based inquiry that will need to be evaluated in a case-by-case basis.
That leads me to the next question, which is, in your opinion, is it in the public interest for SPS to use all of the economically available water at Tolk under the stipulation proposal of retirement in 2028?
No, I don't believe that it is. They do own those resources, but using them faster creates greater risks for customers. And I believe that would be imprudent at this juncture.
Okay. Now we'll transition on to the EAP program. Would an EAP-like program be unreasonably discriminatory today?
I don't believe so. I think it would depend on the specifics of that program. It's certainly possible to construct a discriminatory program, but also quite possible to develop one that's not unreasonably discriminatory.
Thank you. Just because a low-income bill did not pass at the legislature, does that mean a low-income rate is not legal per se?
Not in my opinion.
Okay, thank you. We'll transition now to some of the questions developed in relationship to the cross that was conducted by Ms. Kane.
Okay.
To begin with, I just want to explore the IRP process. Did overlapping deadlines in the negotiations that occurred for this case cause conflicts for you and members of CCAE to attend IRP meetings scheduled by SPS?
In my case, it did, yes. Although I'd have to look to the specific calendar dates to confirm which meetings.
Okay, and is PNM's IRP stakeholder process also taking place at this time?
I believe so.
Is settlement of a New Mexico gas case additionally taking place at this very same time?
I believe so.
Would that limit CCAE participation in SPS's IRP engagement of stakeholders?
I would have to imagine that it would.
Okay.
Did you actually participate in the PNM case or the gas case, Mr. Long?
I haven't participated in the specific negotiations on the gas case, but I have participated in producing information for CCAE's involvement in that case.
And the PNM case?
Myself, no, but I am aware of other CCA members.
Thank you. Go ahead, Ms. Lynch.
Were you present for Ms. Trammell's testimony in this case?
I believe I saw all of it.
Okay, and as she was testifying, did she say that she predicts Tolk will operate at 4,000 gigawatt hours per year if the stipulation is approved?
I wouldn't want to quote her directly, but that was my understanding that she was quite certain that it would achieve that target level of generation.
Therefore, is the requirement for reasonable and consistent progress satisfied by SPS being in compliance with the 2025 or 2030 RPS requirements?
I think the ultimate satisfaction will depend on their performance over the coming years, but I think that approval of increased costs for both O&M at Tolk as well as unlimited NOx cut in the opposite direction and could very well incentivize or encourage the utility to increase emissions, which I believe is anathema to the intent of that statute.
And does the settlement or stipulation proposed here represent a prudent use of the remaining water resources available at the Tolk plant?
Not in my opinion. I think the prudent thing here to do would be to maintain lower levels of generation as needed, such that there's still gas in the tank, or in this case, water in the tank when the car arrives to Albuquerque or the plant arrives to its retirement date, such that if there's delay in any of the acquisition of replacement resources, customers aren't left with no alternative.
Thank you. And regarding the plans put forward by SPS, what improvements might the company have made to its analyses in this matter to evaluate whether the Nichols or Tolk requests were reasonable, prudent, and in the public interest?
I think there's a number of things that I identify in my testimony, including potential climate risks associated with faster water depletion, but principally, I think that the biggest concern I have a lack of analysis of alternatives and timely requests for proposals for real world alternatives that might have met that need, both the capacity need being requested in the case of Nichols and the possibility for greater energy need presented in the case for Tolk.
Would those alternatives have included renewable energy or storage?
I think any reasonable request for proposals would have allowed for renewables and storage, and given costs as presented in Ms. Gliss's testimony from recent RFPs, I think it's likely that there might have been resources available that could have taken up part or all of that need.
Okay. Can you describe your concerns with the broad range of assertions SPS has made on Tolk utilization under the terms proposed for this stipulation?
I don't want to be too redundant, and I know I pushed the limits of the judge's patience earlier in emphasizing these two different justifications, but I am concerned that we have heard witnesses claim both that the dispatch would be purely economic and that the dispatch would be, that the price would be designed with the market monitor to achieve the target level of generation. And I believe that's concerning and sort of an attempt to have it both ways.
Okay. I have two more questions for you. Should the commission defer to SPS's assertions about a possible SPP market withholding regarding a lower O&M recovery for Tolk?
No, I think that the commission retains jurisdiction on prudency and costs and whether or not individual costs are in the public interest, reasonable or prudent. And so I think they have every reason to make those decisions here, and I would recommend avoiding the costs that I've discussed. Secondly, the company has been quite clear that there's been no assertion of market manipulation at their current optimization level, which I believe represents more or less the appropriate and prudent level going forward, given the concerns about water and the concerns about increased emissions that we've discussed.
You are recommending retirement of Tolk in 2028, correct?
Yes, yes, with the conditions that I've recommended.
And at the same time, you are not attempting to urge the commission to insert itself in the regular operation and dispatch of SPS's system, correct?
No, or yes, that's correct. Sorry. I am not attempting to insert the commission into those issues, only with regard to the cost recovery proposed by the company and included in the stipulation.
And lastly, if the stipulation were to be modified to include the recommendations that you have made in your testimony, it's very likely that you would support the stipulation, correct?
I would have no further reason to oppose it. So yes, very likely. I can't necessarily speak to the position of CCAE per se, but I can speak to my own position.
Okay, those are my questions at this time. Hearing examiner, thank you.
Thank you. Just for clarification purposes, Mr. Long, do you recall in what part of Ms. Trammell's testimony that you believe was it cross-examination of a particular party, or where was the what you believe is conflicting testimony with Mr. Elsey?
It was in cross-examination from Ms. Lynch on the expected level of generation. I believe there's at least provisional transcript available, and I could find that citation and send it to you if you'd like.
Not necessary. If you believe that's the section that you are basing your testimony today, I will look for it. Thank you, sir.
Thank you, ma'am.
Is there any question from any party based upon my questions or Ms. Lynch's redirect? I think you're benefiting Mr. Long from the end of the 6th long day. And I think they're questioned out. So you're excused, sir. Thank you very much. Have a good evening.
Thank you, ma'am. And my apologies to Mr. Lee. Thank you all.
Ms. Lynch, anything further from CCAE?
No, ma'am. I did recognize where the confusion may have come into play regarding the labeling of our testimony. It looks like page 1 of Mr. Long's testimony in opposition was labeled Exhibit 2, but then pages after that were labeled as Exhibit 1, and I think that may have caused confusion. I can correct that and send it to you.
As long as your exhibit in the Dropbox is correct, I'm okay, Ms. Lynch.
Okay.
Okay. And I printed different versions of all of the testimonies, and I can't tell you exactly where which version I printed when. So as long as the document that you placed in the Dropbox has the correct number, then I'm fine.
It does on the first page, but not on the consecutive pages.
Okay. I think that's okay as long as we can. Mr. Lee?
Yes, ma'am.
As long as the document's correct on the very first page, is it all right for an exhibit, or do you want me to have it corrected?
It's all right.
Okay. Very well. All right. All right, nothing further from CCAE. So basically what that leaves us with is I have a note that I wrote to myself. Ms. Hardy, check with SPS regarding the time frame for the last bench request.
Yes, Madam Examiner, we are working on preparing that information. We are proposing, I think, to supplement what was in Mr. Ripperger's rebuttal testimony, because he did provide information on line losses around the United States and made some comparisons, but we have some supplemental information that we can provide. And we can do that, I think, by the end of the day tomorrow. We can't perform, a comprehensive study on line losses of rural utilities in the United States. It's difficult to determine exactly what those are and how those are determined. So it's difficult to make sure it's an apples to apples comparison. And so we would have some concerns about the information being considered as evidence in the record, but we can provide some supplemental information by the end of the day tomorrow. So with that, that's a qualification, I suppose.
Okay. All right. And again, I think the instruction was this didn't have to be something exhaustive, but at least, something that compared a relatively same size apple to a relatively same size apple of the same type.
Yes.
Okay, is I really believe what the commissioner was just wanting to have some information on. So
yes.
I believe that's what he wanted. So with your clarification, that would be good. Okay. So where we are at this point is we have, I believe, one witness remaining. And unless Ms. Hardy and Ms. Kane, the company thinks it might be helpful if there is some confusion over SPS's position with regard to the stipulation, or if it would help clarify the record, to recall Ms. Trammell, or if SPS is satisfied that the record will speak for itself as to what its witnesses said, then, I mean, I think I would accept that position too. But I just put that out there as a potential option or clarification. If the company thinks it's necessary, because we all want to be, we all want to have the same information, and if we've already got it, that's one thing, and I mean, you've heard that the CCAE witness, at least Mr. Long believes that there has been some discrepancy in the company's position in this case. And if SPS thinks that it's going to help clarify the record, to provide something additional, or if it's just, if it's just a reference, to testimony, or again, if the company believes that, that the record's clear, what the witnesses testified. So I just put that out there for you to think about. You can let me know in the morning. But as far as, where we are right now, we have Dr. Woolridge tomorrow at 9. The parties can tell me what kind of proposed post-hearing writing schedule that you think's appropriate. And right now, what I'm thinking about having 2 issues briefed, and if parties are of the same position, it could be a joint briefing. I don't know if you all do those, but basically what I see are two issues that the commission might like to have a legal perspective on. And one has to do with the legality of EAPs, specifically as proposed by SPS in this case, and or some old, I guess. Yeah, I'm just going to leave it at that. Legality of EAPs, and then the other issue I think probably should be briefed is the question of whether or not the commission has to accept a specific type of rate case filing. I know that the company has the option of utilizing a future test year, but does the company or does the commission have to actually accept a future test year? So those are the two things that that I'm thinking that might be good to have some legal direction on the parties' positions. And I'm going to go through and get the responses to the bench requests that have been issued. And I have to renumber the only one that's been admitted after checking with Mr. Lee was the Attorney General's response, and it was labeled as Commission Exhibit 2. And I'm gonna, I went ahead and named something else to that, and I'm gonna have to change the number and then get the rest of the commission exhibits. At this point, is there any party that's going to object to the inclusion of the responses? All of the bench requests except purported purported exhibit 3 and 4. All the rest of them are responses to bench requests. So parties need to think about, I mean, I kind of would like to know now if any party is going to object to having those in the record, and or want to have the opportunity to file a response to those bench requests. Which you are allowed to under 1.2.2.35A. Additional evidence. So are there going to be any objections?
Your Honor, I don't believe SPS objects, but I would like to confirm. I know we don't object to entry into the record of the bench requests that we've submitted thus far. I would like to confirm with SPS that we don't object to the bench response regarding the articles, I think, that were provided by the AG.
Right, and I haven't addressed those yet. I'm saying
thank you.
all of them except 2 are responses to bench requests. So, okay, I'm not hearing that anybody's going to object. Then the other 2 are the two references that Dr. Woolridge, I believe, referred to in his testimony, and we'll find out tomorrow about those. But right, so I mean, that could be. I don't know if anybody's going to have an objection to those or not, but I'll find out tomorrow on that. I guess I'm just trying to figure out if all the bench request responses are not. Mr. Lee, if all the bench request responses are not filed yet, when we conclude our hearing, then they can't be a commission exhibit, can they?
It depends on the logistics. I need to go off the record to talk to you, Judge.
Okay. All right. I'll talk to you about it, and and I'll have more information in the morning.
All right.
So we can go back on the record. Okay. Anything else procedural that parties can think of that we need to talk about now for the conclusion of our hearing tomorrow morning?
Your Honor.
Ms. Hardy? I can't hear you.
Some of them hear me?
Now I can hear you. Okay.
Okay. I guess I had an audio glitch. We would like to call Ms. Tremmel back to rebut some of the issues raised by Mr. Long. And also, I think several witnesses have referred questions to her throughout the hearing. And we would like to have an opportunity to have her cover those if that's acceptable and would be helpful. And we could do that tomorrow after Dr. Woolridge.
Well, and I want to be real careful here about providing an opportunity for a rebuttal. I think that can be problematic, Ms. Hardy, unless I offered all the other witnesses that opportunity too. I specifically was offering the opportunity to, if you and Ms. Kane thought that there was not an inconsistency between your witnesses' testimony, and the opportunity to clear that up. But to actually provide additional testimony on any other points that Mr. Long made, I'm not inclined to do that. So
I think.
Go ahead.
I think we had raised the possibility of the rebuttal at the pre-hearing conference, given that under the rule, you can have a direct case response and then rebuttal, because Mr. Long did raise a number of issues in his testimony here today that I think Ms. Tremmel would like to be able to address, but she definitely wants to address the claimed inconsistency.
Okay.
And then there were several questions referred to her by other witnesses for SPS, specifically in response to the commissioner's questions.
I'll think about it, Ms. Hardy. Like you say, my main objective in offering to have Ms. Trammell come back had to do with the inconsistency claim by Mr. Long that I thought could be addressed. And I will, I'll take under consideration the rest of the questions that, or the rest of what you had to say about offering to have her come back. Is any party opposed to Ms. Trammell coming back and providing some testimony?
You know,
No.
Your Honor, this is Kara from CCAE, and I object only because Ms. Trammell was asked clear questions and had the opportunity at the time she was testifying to clearly communicate how TOLC would be operated. And she chose not to do that, or she chose to do that as she understood TOLC would be operated.
And Ms. Lynch, in an effort to get clarification for the record about whether or not the SPS has an inconsistency between its witnesses,
CCAE has actively sought clarification on this matter. That is why the question was posed as to whether Ms. Trammell predicts TOLC to be operated at 4,000 gigawatt hours per year under the stipulation, and she very clearly indicated yes. I just wonder what it would do in this matter to bring her forward to testify again to this very same question.
Your Honor, may I respond?
Who is speaking?
Ms. Hardy, are you finished with Ms. Lynch? That's the
You know, I think SPS has an opportunity to address this matter in briefing, and it may save all of us time in exploring this issue further.
Okay, so CCA's opinion is the witness has testified and should not be given an opportunity to testify again. Correct?
It's our position that she can answer your specific question in briefing, but that she was given a clear opportunity to clarify her responses on the record. And all parties in that instance were given the opportunity to, you know, redirect or recross her had they specific questions about the operation of TOLC.
Okay, very well. Ms. Hardy?
I was just going to respond that Ms. Trammell is entitled to address the accusation made by Mr. Long that her testimony was inconsistent with another witness. And we disagree that Ms. Lynch's questions were clear. And several of them were objected to. So I think it's Ms. Trammell's right to come back and address the accusation.
Okay.
And I think it would help clarify the record.
Okay. Very well. Okay. I will think about this and we'll let you know. You can have her available, and I'll let you know my decision in the morning. But we are going to begin with Dr. Woolridge. And then we'll see if we have anything else. Okay, do we have anything else procedural that we need to talk about tonight? And I didn't hear from any other party that they have a position either way on this. So very well.
Your Honor, this is Major Buchanan.
Yes, Major.
I did have a clarifying question about the two issues that you referenced that you would like the parties to brief. I just wanted to clarify whether all parties are being ordered, whether jointly or individually, to file briefings on these issues. or if it's discretionary.
Well, I mean, I really would like to, find out the parties' positions on these. And that's why I was kind of saying that, I mean, if there's 6 parties that have the same position, that, you could just say that, I think that would cut down on the amount of work that has to be done. But yeah, I kind of would like to know if there's a consensus of positions or not. So I would like to hear from all of the parties on this particular 2 issues. Okay. Okay. Anything else? No. All right. Well, thank you all for your participation. Did you have something, Mr. Smith?
I do, Madam Hearing Examiner. I apologize for not speaking up. I wanted to make sure I had an opportunity, though, just for the record. Sierra Club would support having Ms. Trammell come back for the limited purpose of clarifying this issue about the dispatch of these units. We do support, or we do agree that the discrepancy or apparent discrepancy between her testimony and Elsie's is worth clarifying for the commission.
Okay. Any other party wants to weigh in about the potential to have Ms. Trammell recalled for the purpose of addressing any apparent discrepancy between her testimony and Mr. Elsie's testimony regarding dispatch of Tolk?
Your Honor, I lament the use of the term accusation. And it's also unfortunate for Ms. Hardy to characterize my questions as unclear. I could do the same for some of the SPS lawyers that came forward and asked our witnesses questions.
Right, I understand that, and we're not going to get into name calling. That doesn't work for me. I
agree, it's unprofessional.
So we're just going to go on and address the issue of whether or not any party has any position either way with regard to the potential for recalling Ms. Trammell on the claimed disparity of witness testimony. No one else?
Examiner?
Ms. Drake.
Yes, hi. Just to help you out here, since you seem to want to hear from other parties on this. I know it's unusual and usually frowned upon to bring back a witness for rebuttal purposes in this kind of a circumstance, but LES has no objection to your desire to clear up this question, and so that we have a clear record.
Okay, Ms. Drake. Well, I thank you for that. I wasn't really searching. I'm just trying to give people an opportunity to state their position. Otherwise, depending on how I make a ruling with regard to that, just don't want to hear people later say, well, she didn't give us the opportunity to state our position. So,
I understand, and I would certainly not see this as opening the door to allowing rebuttal by every single witness in every single circumstance. But I also certainly understand your desire to get a clear record, and that this may be a unique circumstance in which it may be warranted, whichever way you decide.
I appreciate that. Thank you, Ms. Drake. Anything further from any of the other parties with regard to potential recalling of the witness?
Madam Hearing Examiner, briefly.
Mr.
staff
Bagacco.
supports- Staff supports bringing Ms. Trammell back to that purpose. Thank you.
All right, Mr. Pagacco. Okay. Last chance today. Okay, very well. Thank you all. We are recessed until 9 a.m. tomorrow morning, where we'll hear from AG witness Dr.